Item number 67 of the supplementary list, my lord. Your lordship, I directed the Odisha Public Service Commission secretary to appear along with the records. My lord, I find that since the item is 67,
We will take up.
if your lordship's the secretary is present here,
I will take up at the first case.
lordship.
He is proceeding in the contempt against us. So I take the liberty to instruct my lords.
But the read-up matter is to 22 millions. Read-up matter to 22 millions. My case is this case, I have claimed for granting it. That is pending sent to 13. And this lordship, last time also I had mentioned that I list this matter because others have already availed that benefit, but my case has been the lordship will state the matter, state the order of that, and lordship may hear this matter so that
make mention matter. Read up the matter 2023 matter, face admission matter. Is not been listed in the last occasion. I'll mention for your
Why your case was not listed?
from the last occasion I mentioned for a lordship.
No, why was your case
wait
not
for
listed?
15 days with the work pressure.
Let us try to understand. We are taking up 2024 matters. Why your matter was not listed?
I have filed several memos before the DR. Madam.
Why?
Is it free from defect?
Yes,
Was it free from defect from the very beginning?
yes.
From the very beginning, it was free from defect.
What is the number?
2789 of 2023.
Give your slip, you will see. You just may write in your mention slip that it was free from defect from the date of filing. Mention that.
My lord's permission.
Just. Yes.
My lord's permission. That item number 30 can it be taken up next week?
One is a matter for pension, another is appointment.
Contempt matters are not urgent. When did you file your contempt application?
One is 2023, another is 24.
So give the slips to him.
I may permitted
And make a mention after 2 weeks.
Yes.
I may permitted to make a mention, my lord. It's a matter regarding supply of PDS material.
Supply of
PDS material. We have filed IF of vacation of stay order. Pardon to mention, your lordship, my lord. Is CMAPL applications for restoration of the file, your lordship.
It's an application to review the judgment passed by Honorable Justice Jaswant Singh and MS Sahu, Justice MS Sahu. My lord, a bench was comprised of Justice B.R. Sarangi and Justice MS Sahu, but Justice B.R. Sarangi is not there now. My lord, bench maybe.
Is he your friend?
My Honorable Justice B.R. Sarangi.
All right. All right, give your slip, we will see.
Number 2789. 2020. Nana, cash admission 2023. Mr. Mahapatra, what was the number of your writ appeal
2789.
of 2023?
Yes.
Writ appeal?
Yes.
Are you sure? Writ appeals can't have 4 numbers. I think that is.
Madam.
Writ appeal, 4-digit number, I find that is a little doubtful. Must be 3-digit. Are you sure? Because it's not showing in the registry. Website. Varla. Okay. 2789 of 2023. List hai nahi? Okay, all right. He's found the number.
Item number 67.
So the secretary is present here.
Yes.
And my lord,
had
No,
directed to prepare a chart, my lord.
do you exactly what the commission has done? You appreciate fully.
Definitely.
Then do you intend to rectify what have you done?
Sir, actually, sir, there are 14 questions wrong as per the.
Forget 40 questions.
Oh, one four.
Just a minute. Just a minute. Let us understand whether you have accepted the revised list, revised marks or not.
Yes, sir, we have.
Commission has
We
accepted.
have already sent to government, commission of regulation.
All right. So you have accepted that.
Yes, sir.
So based on, do you realize that the persons having less merit are working and those having higher merit have not been recommended?
Sir.
So it is whose duty to recommend?
Sir, actually, sir, we have already intimated the government.
There is no question of intimation. You don't intimate. Your constitutional duty is to recommend, whether you have recommended or not.
Sir, we have sent the revised list and recommended those candidates.
All right. Show us the recommendation.
Sir.
Commission must be revised recommendation. Where is that?
Recommendation question.
One revised.
Show it.
Yeah.
Page 18 may kindly be sent. The two pages, lots of you seeing page 19, page 18 is also there.
This is how you make your recommendations.
Sir, revised merit list, sir.
This is the way of making recommendations. You send the notes to the government.
No, sir.
So where is the first recommendation?
The letter again.
There must be a letter in the file,
A letter again.
copy of the letter.
Letter is there. Yeah, is there. Last. It is, sorry, it is in the, it's there.
Flag mark, sir.
It is flag marked. You may kindly see. On 4/11/2022. Lots of kindly see the index page. In the index page, we have written copy of the recommendation, that is 8. Copy of the recommendation of 8 new candidates after revision. Eight. Yeah.
About the flag marks, okay, where?
So the last,
Just a minute.
last but one.
Just a minute. So this is your revised recommendation. So whether your names figure in this list or not.
Is not there. His name is not there, man. Thank you, madam.
No, but what was the minimum marks? No, those who were not selected. Those who were not, what was the minimum marks?
You are the minimum revised.
See, you recommended that these persons should continue. Now, for example, for unreserved, what was the minimum marks of the candidate at serial number 118?
First page of that letter.
Revised is 187.
Just
Sorry.
something which could have been resolved by your a clerk in your office is to be resolved by the High Court. Just tell us what is the minimum marks. So all of them had a right to be appointed.
Minimum mark you are revised, sir.
Forget revised.
The
You're
pre-revised,
understanding?
before revision.
Before revision, come to your, see your own recommendation. Do you have a copy of your recommendation?
Sir.
4/11/2022.
We have allowed candidates
Pre-revised, yes,
whose names did not appear in the revised list. So anybody standing above them has to be appointed.
Sir, what topic, sir? Pre-revised is
Yes, sir.
you are female 189.558, female 188.369.
Can you come to your recommendation?
Sir?
Can you come to your recommendation 4/11/2020?
Sir.
You still need to specific, you know. Do you have a copy of this letter dated 4/11/2022?
Sir.
All right, please come to the.
Sir.
Now tell us, what was the marks obtained by candidate at seventh candidate,
Sir.
unreserved?
Sir. Uh, 188.834.
188.834.
Sir.
And for this SC?
Female, sir. You are female, sir.
All right.
In your quota.
And this, and you are male?
Your male is 189.558. 189.558.
That is serial 6.
No, sir, that is in the pre-revised list, the serial number 113, sir. Ma'am.
So all these URs are male or female?
189.55.
So this marks 188.834. Revised.
Unrevised.
We are asking revised because the merit list is to be considered on the basis of revised.
Revised, ma'am.
marks.
192. No, no. Revised. Cut off. Revised cut off the
All right, let us understand it in a different way. These are 8 candidates
Sir.
who ought not to have been selected. But you have recommended to the government that they should be allowed to continue. So which candidate had the minimum marks based on the revised marks? Whether our question is logical or not. Which out of these persons you have recommended that they should continue. You have also accepted the revised marks. So what was the minimum revised marks of these candidates?
Sir, that is 192.558, sir. 192.558. No, correct.
558.
It is the revised cut off.
Who has got 192.558?
No, sir, yes, sir, 192.558 for female and female was 192.423, sir.
192.558 female.
No, 192.558 is for male, sir. You are male, unreserved male.
Male.
Sir,
And female?
192.423.
192.423.
Sir.
This is revised.
Sir.
So who is the candidate amongst these 8? 7 rather. We will see SC later. So who is scored 192.558? This is revised, you are sure?
Yes, sir.
So persons with this mark,
Sir.
they are working. Persons with this mark, 558 and
Yes, sir.
192.423, they are working.
Are they working? No, sir, that we do not know, sir, actually.
All right, all right. They are.
Yes, sir, we have sent the list, sir, to government, sir, but what is there, yes, sir.
So how many persons are there above 192.558 who were not recommended?
Sir, we have recommended all, sir.
You're not understanding. There is a cutoff mark
Yes, sir.
in the revised list.
Sir.
All right.
Yes.
But there are some people working who may be below that cutoff mark.
Yes, yes.
So we know the person who has obtained the least number of marks, how many people are above them? They might not have got the minimum cutoff, but how many are
All
there
right, we are
above them?
giving you one example. What is your revised marks?
This revised, my lord.
Just a minute, let him say.
191.210.
190?
191.
What? Just a minute.
191.210.
191.210.
And 192.002. Two candidates are before you.
002. So let us know whether any person below you has been recommended and is working.
I have prepared a chart according to your lordship's direction. I'm just 1 second. What happened with it?
No, this is the direction which I have.
Your lordship may turn to last page. The colored names were previously recommended by the OPSC.
Yes.
In the chart which has not been colored, those names were recommended by OPSC to the state government for appointment and they have already been appointed. After the judgment,
Means 128 were appointed.
129. Your lordship, last number I have made the red mark. 129, roll number is 101250, male, unreserved, pre-revised mark, he had secured 187.934, revised marks, he has secured 184.993, you are appointed. And all these persons from serial number 119, I have, my number I have left blank because they have not recommended my name. My roll number is 101074, another candidate 101716. These, except these two candidates, all other candidates who have secured less mark than me from serial number 121 to 129 have been recommended and have been appointed and continuing in service. If this data is incorrect, the Learned Secretary may reply this. I have prepared this as per the merit list supplied by them.
076. So you are male, female.
A male, two male.
One zero. They have given roles. No, that's fine. Indeed. 101419, right? Yeah.
You sure the roll numbers are?
As per the affidavit shown by the Secretary himself, filed before this Honorable Court in writ appeal, I have prepared this chart. Any of the information is not correct, the Secretary. And the Honorable Single Judge specifically, during the course of argument, pointedly asked the counsel appearing for the parties, that is reflected in paragraph 45 of the judgment, that what is your reply, that two candidates secured less mark, they could be appointed, recommended and appointed, how the petitioner could not be. And paragraph 45 of the judgment dealt with that. And that has not been challenged in the writ appeal. Not a single word whispered in the writ appeal that this is the fact that the Learned Judge is incorrect.
I think.
So that is that, Mr. Samal.
Madam,
This chart which you have given is as per the information provided by them.
provided by them.
This
Yes.
doesn't tally the table they have given, because serial number 125 and 128 doesn't figure in the list.
My lord,
125,
Roll numbers are different. Roll numbers are different.
roll number,
Roll number is different.
yes. So some people are also working without
My lord, I need
your
to,
knowledge or what?
I need to check it up, my lord, this.
my lord,
document,
this
my lord and friend.
101415,
Yes,
if your lordship will have a glance to the affidavit they have filed, Let the affidavit dated 25/7/2024.
But I hope you're listening.
25/7/2024. A affidavit filed in the writ appeal. Kindly have a glance to page 19. Page 19. Internal page 19 of your affidavit.
Do you have the mark sheet of revised and of merit list with marks
Yes, yes, ma'am. That we have given, my lord.
we have given?
Yes. But may kindly see the index. That 9. So last,
Page-
last
My lord, regarding
flag.
twice one name has been recommended. My entire endeavor is to show one. Therefore, your lordship, I requested page 19 of the affidavit dated 25/7/2024. They recommended in serial 101485. The date of recommendation 11/1/2019. Next page 20 recommended from 6. You are same candidate.
But both times.
You are yes. The roll number, your lordship, may kindly have a glance there. The next page 20. Same roll number in page 19. 101485.
No, this is different. This is different.
How can a candidate twice recommended even after appointment? He has already appointed. He has already appointed.
Mistake that way.
That way, yes.
No, because she figured in the select, above the category, that is right.
If someone was recommended in 2019 and after, she again recommended in 2021.
That may be a mistake because she has got the
Yes.
above the cutoff.
Yes,
That-
above the cutoff. Yes. That is how their list prepared is not correct.
That somebody may have missed while adding.
Se lista material देवे कि अपन लेकर देखते हैं proof को।
Copy. Sir, good copy.
What are the roll numbers of your
101074
101074? Yes.
and 101716. Two can
1716. Just two.
Two.
Only two.
Only two. And the honorable single judge had directed to kept reserve of 2 seats, and accordingly they have kept reserve 2 seats. You have passed the order.
So that's another advertisement.
Yes.
Another order.
Yes.
Who did you say has been recommended twice? Roll number? Just give the roll number.
One 101485. 101485. One more fact, my lord.
And Mr. Tripathi, letter of yours, it says that 101485 has already been appointed.
I need to my lord also. Find it,
Delegate.
my lord. These are the, my lord, your lordship is asking, lordship may kindly see the headings which will be written. Recruitment to the post of dental surgeon pursuant to so and so. Revised mark of 6 recommended candidates selected after preparation of the revised merit list. That what had happened is, my lord, what my lord time they have been recommended, this person 101485. With regard to that fact, my lord, I'll
No, I'm not looking at what he's saying. What he said, I'm looking at your letter. Remember letter.
but
There is specific in the affidavit itself.
no, I'm
Yes.
disputing.
Yes, yes.
You're not fighting on issues.
So how many posts are vacant now?
My lord, in the subsequent advertisement, after the law in single judge, my lord, order, we have kept 2 posts, my lord.
For the order.
Yes, ma'am.
But what about this list you have said that if they represent, then it may be considered. They have, they don't.
They
know,
have not
applied.
represented. They are not represented.
They don't even know that they could have been appointed.
My lord.
One particular. Because you did not publish the list.
So because of your recommendation, appointment of which candidate has been saved? So he had scored less marks. So whose appointment was saved?
8 of the persons. 8%. These 8, my lord.
What is the minimum marks? What is the minimum marks scored by them?
These 8 candidates. What were the marks last candidate? Re-revised as well marks.
Not re-revised, revised.
Revised. It was the last. We have given the red color one, my lord. Also, may kindly see the.
Actually, the serial number you have given doesn't match with this. That's why I'm not able to find because I didn't found out.
I have given these 129 candidates have already been recommended and appointed. And out of them, the last candidate who has secured the revised mark is 8.934. My learned
187.
friend is misleading by not correcting, giving the correct fact as per their own affidavit.
So
The
all right,
last
do you
candidate,
have the, Mr. Secretary, do you have the entire chart with you of selected candidates?
Sir.
Just tell us, what is the marks scored by a person having roll number 101415? We don't want to summon the chairman of the commission. That we don't want. And please don't compel us to do that. We have put a very simple of only 177 candidates. So what was the marks scored by him? 01415. Female.
Your Lordship is asking 101045.
101-101-415.
101.
All right, tell us whether someone who scored 189.324, unreserved candidate, is working or not based on your previous recommendation. And subsequently, because you saved his,
He might be working, sir. He might be working, sir.
might be working. So when you are saying that minimum cutoff marks is this, and this person is working, then what should be the minimum cutoff marks?
In the revised one, 91 point some.
Revised one, but this person is working. If that is your cutoff marks, then how a person below that can?
But should have removed it.
And that name is not there in this list.
And why his name is not there in the list of 8 candidates, or it could have been 9.
You have said only 8 candidates who did not qualify are working and allowed to work. But these names do not figure in the list of 8. That means there are more persons who are working who have not qualified. Either clerical error or deliberate error, you have to check.
I have to say, I think, sir.
Let me not examine this and come back.
Sir, I will comment, sir.
Every day, see, our difficulty is that we cannot
I am
Legal
filing
fact.
the affidavit.
Yes.
As I had requested, whether an unreserved candidate. He was considered. It is normally is also in the regular process that is done. But it is found that in the unreserved, the last candidate has secured 116 point something. He has secured 90 point something. So far the locomotor reservation is concerned, he is claiming he cannot be considered against that because once he is considered unreserved. Because the reservation, what category of candidate he has applied for. Now reserve, he has applied for the scheduled caste. Within the reservation, that will be a horizontal reservation. Vertical reservation, within that horizontal reservation. So that is why he has not come within that. So he has secured 90 point something, but the last candidate has secured 116 point something. Accordingly, we have filed the application.
You mean to say in the unreserved locomotor deficiency category, he cannot be considered?
Cannot be
He
considered.
can only be in the open category.
Because he has applied for the schedule.
Unreserved is open.
Huh. He's not getting that.
Even if he doesn't get it. See, where is your advertisement?
Advertisement is there, Mullah,
Page 34 alerts.
in the right, in the right
In
place.
the writ appeal, page 34 alerts.
Page 34.
Therefore, see the advertisement. Yes.
Let's kindly see, kindly look at page 34. Vacancy position, that is paragraph 2. As per requisition filed by the Home Department, Government of Odisha, the vacancy position along with reservation thereof is below. On reserve 41. 14 women candidate. So thus 27 for the main candidate. Scheduled caste reservation, that is 4. 4 women.
That is the only question. That if a candidate cannot be considered for this thing, if and where is your reservation for physically challenged?
That paragraph, subparagraph,
Where?
Last.
that paragraph 2 subparagraph, out of the total. Let's see,
Yes.
got it.
Yes.
Out of the total 46 number of posts, as mentioned above, 4 posts are reserved for persons with disability whose permanent disability is 40% and more. 4 posts are reserved for ex-servicemen and 1 post is reserved in post person. Candidates belongs to
So
PWD
did
category.
you fill up any person against locomotor disability?
Yes, we have filled up.
Filled up?
Yes, that we have given that.
How many?
We have given that.
Only one.
Just a minute. How many?
You will also kindly see page 55.
Disability. One post of this the
Locomotor.
locomotor has remained unfilled.
Yes, yes.
You'll have to fill up.
But what is that type? What
But-
was locomotive?
But perhaps I have not been able to
Yes, what?
convince your lordship.
Your submission is that because he claimed to be SC category candidate,
SC.
candidate, therefore his candidature cannot be considered against unreserved.
No, he was considered as against the unreserved candidate as general candidate.
No.
But so far the locomotor is concerned, he cannot.
That is all.
Yes,
There is no unreserved locomotor.
there is no question of unreserved.
No. Have you made any appointment for unreserved locomotor vacancy?
Because those were the
Have you
candidate on.
made? Yes or no?
Yes,
So
we have
that,
given that.
so that we are asking, have those posts been filled up
Millard,
for locomotor in
Millard,
unreserved category?
Millard kindly appreciate.
So please say yes or no, then we'll go to what you are saying.
That it is very apparent from page 55.
Yes.
We have appointed one on reserve and two on, sorry. You are locomotor serial number 40,
Sir, there were 4 posts reserved.
4 posts.
Whether you have filled up all the 4 posts or not.
No,
That is the question. The act mandates you to fill up if the candidates are available.
but the candidates not available.
He is available.
Lordship kindly understand.
Yes.
Yes,
Kindly
we
understand.
can.
Because,
We can understand.
right, but one thing is that he applied as a scheduled caste candidate.
No, we have.
We can consider him as an unreserved candidate if there is no post for a scheduled caste. Said there is no
No.
post for scheduled caste.
We have understood
Reserve.
what you are saying. You are saying because he had applied as scheduled caste, whatever locomotor,
Yes,
he could not get it either in the locomotor or in the scheduled caste. So you have considered him as unreserved,
unreserved.
but he did not qualify.
Did not qualify.
Okay, all right.
So
We
it
are
is-
saying that if 4 posts are reserved for locomotor disabled persons, then, and you have not filled up a post and he otherwise qualifies, why can't he be appointed?
that is the catching point.
Yeah, exactly,
The catching point is that
exactly.
the horizontal reservation is within the vertical reservation.
That is all.
Once is selected on the vertical reservation, then he will be considered as against the category reserved for that.
Oh, you are saying,
Yes.
you are saying
So
only
that is the
unreserved.
law.
Where from you have got this principle that horizontal reservation shall depend
Well,
on
that-
vertical
That
reservation?
circular we have given that, the GF Department circular, basing on the Supreme Court judgment. The horizontal reservation is a small wheel within the big wheel of the vertical. The horizontal has to come within that vertical. Somebody comes within the vertical reservation, then he can be taken into consideration within the horizontal reservation.
All right, very good. Did you provide that one post of this disability, locomotor disability shall be reserved for the scheduled caste? The question of horizontal reservation and in the vertical reservation shall arise then only.
Well, first the vertical reservation,
First
then
vertical
horizontal.
reservation, we are giving you the principle.
Yes.
If there were 40 whatever posts and 2 were to be reserved for locomotor, you should have started from the top, if whether 2 persons are coming or not. The moment you reach a conclusion that 2 persons locomotor disability are not coming, they will have to be adjusted. This is the law.
But one thing, Lordship kindly appreciate. This can be answered by the government because we
This
are
cannot
bound
be
by the
answered
government
government.
requisition.
This should be answered by us.
Can I?
That is right.
Can
But
I
Lordship
actually
kindly have a look
Just
at
a minute.
the
Just a minute.
look at the requisition. Sorry, that my Lordship kindly look at the requisition. Sorry, advertisement, page 34. Page 34.
Yes.
Lordship kindly see. Out of total 46 number of posts, as mentioned above, 4 posts are reserved for personal disability. Permanent disability is 40% and more. 4 posts are reserved for ex-serviceman and 1 post is reserved for sports person. Candidates belonging to PWD category, ex-serviceman and sports person shall be adjusted against the category to which they belong.
Yes.
So, beloved, he is a scheduled caste.
Yes.
So that is why she is considered as a UR candidate, but applied for scheduled caste. So he
Yeah.
cannot occupy.
It's such a wonderful argument you are making. So had he not been SC, he would have been selected. This is your submission.
No,
Is
had he
this your
been,
submission, Mister? Is this your submission that had he not been belonging to SC category, he would have been selected?
no, I am not saying that.
Yes.
I am saying that had he been a scheduled caste, and there would have been a reservation.
All right. Had he had against SC post, he would have been selected.
Had
This is
he,
your submission.
had he applied only for locomotor disability without SC?
No.
No. Look,
For SC. He applied for SC and
I'm saying had he not
Had he applied
only for locomotor.
only for locomotor, not against SC, he would have been selected. This is your submission.
No, I mean, you may not be submitting, but the effect of your submission is that. Right? You are saying because he applied for SC, he cannot be considered here. But had he applied in general,
You are candidate.
yes, you are but locomotor. He
You are
would have-
local.
Or let's say only locomotor, forget about reserved category. But this is horizontal situation.
He would have been selected.
That
And
is it.
because-
You are candidate. But he applied as a
It's all right.
scheduled
It's
caste.
all right. He applied because he thought he will get a better chance.
That
whole
Therefore,
That is what we have relied on, because the lordship can say under article 320 we have a limited jurisdiction. We have to abide by the government guidelines. That I have given that documents annexure A by.
Sometimes you can
So in
misread
that-
the guideline also. So let us.
Can I
They have
assist
said
your
that
lordship?
within a big wheel it comes as a small wheel.
Can I get a chance
Within
to assist?
vertical that will become horizontal.
all right. That's all.
You want to
That
assist?
we have.
I want to assist.
Are you there in the case or you
I am
want to assist?
appearing for 14 of the
Oh, you are
persons who are selected.
appearing.
Can I get an opportunity to assist your lordship, my lords? Let me take your lordships to page 34. This is the reservation, my lords. I'll not repeat anything said by my friend for the senior friend, my lords. The category is vacancy
No,
position.
this appeal is by one person.
My lord, this is by one person.
By one person.
He has made all of us parties, opposite parties.
All right.
My lords.
But whether you are going to get disturbed
My lords,
because as against one post has not been filled up.
my submission is, my lords,
Well,
What-
46
all the
have been
posts-
filled up, 46. We have recommended 46.
That is total.
my submission is, my
You have recommended all 46.
All 46, including 3 disabled.
Then you may have to face prosecution also.
my lords, I'll, that situation may
What
not
your
arise.
lordship direct we are bound by that.
Yes.
But
That
the last
position
candidate may suffer.
So you are unreserved or against the reserved?
My lords, I am appearing for, my lords, that position may not arise. I'll just tell your lordship why. I'll tell your lordship what. The vacancy, the petitioner, my lords, is a scheduled caste male, my lords. Now, the reservation prescribed here is scheduled caste woman, 4 posts for scheduled caste woman. And then, my lords, the next, out of the 46 number of posts, as mentioned above, 4 posts are reserved for persons with disability whose permanent disability is 40% or more. 4 posts are reserved for ex-servicemen and 1 post is reserved for sport person. We are not concerned. Candidates belonging to the PWD category, ex-servicemen, sports quota shall be adjusted against the categories to which they belong. So therefore, my lords, if under the vertical reservation, scheduled caste women are not available, then, my lords, you come next, my lords, we move on to the horizontal reservation. Once the social category is not filled up, not available, then, my lords, we move on to the horizontal reservation, the special reservation. Then, my lord, this says at the next page, your lordship may kindly turn to page 35. In case of non-availability of eligible suitable woman candidates, the unfilled vacancies shall be filled up by eligible suitable male candidates of the same category. This is the next, my lords. Now, this thing has been, my lords, explained clearly in the Supreme Court judgment, my lords, the 2007, volume 8, SCC page 785.
This-
volume.
My lord, 785. I'm passing on the judgment, my lords, copies of the SEC citation, my lords.
Yes.
This is that case of, my lords, Rajesh Kumar Daria versus Rajasthan Public Service Commission. This has explained concept,
Yes.
my lords, very lucidly. Paragraph 9, your lordship may kindly turn to
No,
page 7.
whether this is with reference to PW,
My lords, vertical and horizontal.
only vertical and horizontal.
Vertical and
This
horizontal.
act has been taken into account or
My
not?
lords, yes, only vertical and horizontal, how they have to
Vertical and
adjust.
horizontal, that must have been discussed,
My
but
lords.
with reference to this act or otherwise?
My lord, otherwise.
Otherwise.
Not
Other-
PWD, PWD slide.
All right.
They talk of
All right,
special.
all right, please.
My lord,
Paragraph.
lordship, kindly bear with me. 9. Paragraph 9. The second relates the difference between the nature of vertical reservation and horizontal reservation. Social reservations in favor of scheduled caste ST, and OBC under Article 16(4) are vertical reservations. Special reservations in favor of physically handicapped women, etc., under Article 16(1) or 15(3) are horizontal reservations. Where a vertical reservation is made in favor of the backward classes, under 16(4), the candidates belonging to such backward class may compete for non-reserved post if they are appointed
That
to
is regarding vertical reservation.
my lords. Vertical reservation. Lordship may kindly my lord, allow me to read the whole paragraph, my lord, then your lordship will get a.
We will allow you to judgment.
I'm obliged, my lord.
Yes, please read.
My lords.
Which paragraph, Mr.?
Paragraph 9
All right.
starts from page 790 bottom. Where a vertical reservation is made in favor of a backward class under Article 16(4), the candidates belonging to such backward class may compete for non-reserved posts if they are appointed to non-reserved posts on their own merit. There is no quarrel in that proposition, my lords. Their number will not be counted against the quota reserved for respective backward classes. Therefore, if the number of SC candidates who by their own merit get selected to open competition vacancies equals or even exceeds the percentage of posts reserved for scheduled caste candidates, it cannot be said that the reservation quota for scheduled caste has been filled. The entire reservation quota will be intact and available in addition to those selected under open competition category. That is the ruling in Indira Shahani, R.K. Sabharwal, and Virpal Singh Chauhan Mala. But the aforesaid principle applicable to vertical social reservations will not apply to horizontal special reservations. Where a special reservation for women is provided within the social reservation for scheduled caste, the proper procedure is first to fill up the quota of scheduled caste in order of merit and then find out the number of candidates among them who belong to the special reserved group of scheduled caste women. If the number of women in such list is equal to or more than the number of special reservation, there is no need for further selection towards the special reservation quota. So, what this judgment says is, only if there is any shortfall, the requisite number of scheduled caste women shall have to be taken by deleting the corresponding number of candidates from the bottom of the list relating to the scheduled caste. To this extent, horizontal special reservation differs from vertical social reservation. Thus, women selected on merit within vertical will be counted against horizontal reservation for women. Let us illustrate by example. So here, my lords.
All right. Here our doubt is
My lords.
whether the principle will be a little different for this, because this is a special act. That is our question.
My lords.
This is the principle normal for vertical and horizontal.
That's right. My lords.
Whether
That's right. My lords.
regarding this Rights of Persons with Disabilities Act,
This also talks about physically handicapped women.
what is that?
This should first line, this page 191. Reservations in favor of physically handicapped women, etc., under 16(1) to 15(3). So all these special reservations are clubbed together under horizontal. So that way, my lords, my most humble and most respectful submission is, my lords, that the act may not.
Just.
No.
Yeah, here, Mr. Palit, they say,
Yes, Manoj.
if the number of women in such list
Manoj.
is equal to or more than the number of special reservation quota.
Yes.
What do you mean by special reservation?
Special physically
Horizontal?
handicapped.
Horizontal?
Physically handicapped.
Yes.
Manoj.
Then there is no need for further selection.
Manoj. So
They are saying that if
once
this special category has otherwise been selected under the normal,
Manoj.
then there is no need.
What this judgment says is, once the vertical reservation is satisfied
Vertical.
of that
reservation is
quota.
Satisfied.
We are again putting the same question.
Manoj.
Covering.
Had he not applied against
SC.
the SC vacancy,
Manoj.
whether he would have been selected or not?
He would also still not have been selected.
Right.
Because Manoj, on merit, he is lower than even the last candidate.
That regard
So
to
had
what?
he been above the last candidate, he would have been otherwise selected.
Otherwise selected. So here, my lords, even the last candidate, that is, your lordship may turn to page 55.
No, our question is simple. There are seats reserved for persons with disabilities. All right. So if he was not selected against SC, why could he not have been considered under UR for that post?
Manoj,
UR, there is a reservation for PWD.
UR is not a reserved category.
No, it is not a reserved. But
UR is a,
PWD, there
you
is
can only have, Manoj.
horizontal.
Manoj. PWD is only for
So
horizontal.
we are again repeating the same question, Mr.
Manoj.
Palit,
Manoj.
that had he not applied as SC candidate,
Manoj.
whether he would have been selected or not.
Had he not applied as an SC candidate, only on locomotor. So your lordship is, Manoj, what your lordship is indicating is whether there could have been a separate category of
Forget separate category.
reservation.
You have read the principle of
Manoj.
vertical reservation and horizontal
Manoj.
reservation.
Manoj.
We are putting a very simple question.
Manoj.
Had he applied as a general candidate
Manoj.
with that locomotor disability, whether he would have been selected or not?
There was no reservation for the category.
How do you say?
Because Manoj, that is what.
Are you suggesting
Manoj.
that the reservation for locomotor was only for SC?
Manoj, vertical, horizontal reservation.
Forget vertical, horizontal.
Manoj.
Simple locomotive.
Whether
Simple
all right,
locomotive.
forget
Manoj,
that he
I
belonged
get your
to SC
lordship's
category.
question.
Forget that. Let us.
I get your lordship's question, Manoj. Simple locomotor, there was no reservation to that extent
All
here.
right. So how do you read this from the advertisement that there was no reservation for no requirement of considering this reservation against UR posts?
Manoj, I would only read it from here that in the second part, candidates belonging to the PWD category, ex-serviceman sportsperson shall be adjusted against the categories to which they belong. That is,
So
my
a
lord.
person, Mr.
Manoj.
Palit, who belongs to a reserve category,
Manoj, I get your
also
point.
belongs to
I get your
unreserved
lordship's point.
category.
I get your lordship's point. Manoj. I
Because
get your lordship's
unreserved is not a category.
Manoj, I get your lordship's point, Manoj. I've got your lordship's point, Manoj. There is one.
I've got your lordship's point, my lords.
Another query I have.
My lords.
Has anybody been given appointment in UR against locomotive?
Yes, one.
One has been
One
given.
person.
What
That's
is
why
Marks.
his marks is much more, much more.
No, locomotor disability?
Yes, even locomotor he is much more.
No, he's saying locomotor, one person has been given.
Harihar Maharana, that is a serial number 40. 50% locomotor disabilities. Harihar market. That is there.
Then he would have been considered.
110.
Let's see.
110. He has got 110.
Is.
Yes.
One person has been appointed.
No, one person has already got
That's all right.
50.
There are
So
two.
I am
One person suffering from locomotor disability
Has-
has been given
40,
reservation.
40, serial number 40.
All right, fine.
Serial number 40.
4 marks.
Man.
That is all
He has
right.
got 110.
All right.
So now, my lord, there's one more development which would be of crucial importance, my lord. It can solve the entire issue. My lord,
Yes, what?
that is that 41, Lalita Patra SC female has left and joined judicial service. So that vacancy still exists.
No, that vacancy stands filled up the moment the candidate joins.
No,
The,
she has left.
even if she has left,
She
he
never.
has left, the vacancy stands consumed.
She,
The vacancy no more survives if a person joins.
That vacancy would be.
That is not a vacancy.
No,
That
sir, it
vacancy
was
shall be
consumed when she
advertised.
joined. It was consumed when she joined.
Vacancy can be advertised.
But now, my lords, the position as it stands,
No, let us understand. Let us be
Well-
clear on the facts.
my lords,
There are two posts reserved for a locomotor disability.
my lords.
Which person has been appointed?
One person, Harihar Maharana,
Harihar Maharana.
no other person has been appointed.
Harihar Maharana has been appointed.
40. Serial number 40.
Sir, Palit, I think you're wrong. One must have been given in that SC category also.
SC category.
Category 1 must have been given.
Category
That is why
1.
this comes-
Visual.
Alright, just a minute. So 40 suffers from disability.
My lords, 50 locomotor disability.
40.
My lords, serial 40 suffers from locomotor.
Serial 40 in the merit list.
List.
All right.
Take
And
55.
who is the other person who has been given reservation?
My lords, PWD category is that category 1, 40%. Lower vision, visual impaired,
No.
43.
So, please, locomotor disability,
Locomotor, nobody else, only one.
according to you, the person, he has not been given reservation. The person at
Hmm.
serial number 40 has not,
No,
he has qualified on his own merit.
my lords.
All right.
Ma'am,
So he
you are.
satisfies the requirement of horizontal reservation, at least for one post.
My lords.
So whether horizontal reservation has been given to any other candidate in any other category or not?
Has been given to two candidates in visually impaired. 43.
So what about SC? In SC, whether any reservation has been given or not? Or SC was for women only.
SC was for women. SC was for women, my lords. SC four SC women have been selected. That is, my lord, serial number 39, serial number 41, serial number 42, and my lord, serial number. There's one more judgment which comes to probably our aid, my lord. Your lordship may not have to, my lord, because these people are already working for two years.
Maybe we will see what can be done.
There's one more judgment, my lords, which can come to your, my lords, our aid.
Yes.
That's 2019, volume 11, Supreme Court cases, page 771. Here, my lords. One candidate, my lords, after joining, resigned. And that, my lords, candidate was, that post was directed to be filled up by, it's paragraph 5.
That was directed to filled up by Supreme Court.
My lords, in 136. It was there. So, my lords, to mitigate these people have already worked for paragraph 5, my lords. If your lordship permits me to place 5. We are afraid this contention cannot be appreciated. No doubt, no candidate has a vested right for appointment, but at the same time, the appointing authority cannot frustrate the whole instruction behind and purpose of preparation of a select list. If a vacancy had arisen before the expiry of the list, going by instruction, the next available candidate in the select list had a legitimate expectation and claim for being considered for appointment. A vacancy had arisen in 2014 before the commencement of the fresh selection in 2016. Even for the subsequent selection, the post reserved for Balmiki Majbi Sikh is not notified. The reservation is for other scheduled castes. The Learned Council for the state has stated that vacancy of the Balmiki Majbi Sikh has not been filled up and is still available. So therefore, the slot reserved for Balmiki Majbi Sikh is still available, and as per the instructions which we have extracted above, the same has to be filled up from the merit list. In the additional affidavit filed by the state, it is pointed out that the appellant was not the next person for consideration. It is one Maninder Singh. He has also given a representation. Since the slot is available, the state has to fill up the vacancy community from the merit list. In case number 2 is not interested, naturally it will go to the appellant. So therefore, my lords, my submission, basing on my lords, drawing sustenance from this Supreme Court judgment is this, my lords, that post of Lalita Patra is still available, and that is my lords of an SC, my lord, the reserved post, my lord, that is still available, and this candidate having applied for, my lords, under SC male can still be adjusted by your lordships.
But is
You'll
that
see.
anywhere on record?
That's on record. That my learned friend for the state.
That have you is that on record? Not admitted. It is
And she
admitted,
joined
but we
judicial
need to
service. My learned friend for
He
the state.
applied for the SC candidate.
You're not saying that. What
Vacancy.
you're
And we have
saying-
also said in the affidavit today filed.
that one post is vacant.
That is the list you have given, my lord, page 20 in this affidavit.
No, vacancy, Mr.
Your
Kunti, I
lordship
can say.
bring on record the today affidavit you have filed.
Achi vacancy, vacancy.
Where have you filed that affidavit? Affidavit is here.
Today I have filed.
This is not the place for filing. So you say today you have filed.
Have you filed any affidavit that someone resigns?
No.
It's fact on record.
That information may not be with my learned senior friend. It will be with my friend for the
We are
state.
asking, is it anywhere on record? Because unless it is there on record, this way, that way, we cannot consider.
No, the state may be asked to take instructions on that. We have definite information that she has resigned and joined judicial service. Lalita Patra.
That I cannot say. Please cannot say.
And that's what I'm saying. So state will.
Yes,
Your lordship, can you take on record the today affidavit? you have?
file it.
My lord, today I passed on to your lordship today.
An affidavit has been filed on behalf of.
Yes.
Taken.
Can I have one last prayer, my lords? My learned friend for the state can file a instruction before your lordship can call for that instruction of
See what order.
that vacancy.
We'll see.
Lalita Pradhan.
Lalita Patra. Serial number. Lalita Patra, serial number. Page 55, the serial number. Lalita Patel, serial number
41.
41. 41. Serial number 41, SC female. Serial number 41 is vacant. She has joined judicial service.
So the next process of selection has begun.
My lords, no. No. It's still. And she, my lords, left during the pendency and currency of the validity of the select list also. Your lordship's own judgment is there, my lords. Well, lordships have held that there's no thumb rule that with the, my lords, lapsing of a year, the select list lapses. This was within that 1 year period. Select list lapses in February. She resigned in January. 16 January, 1 month. Also.
That post cannot be filled up. Because one has joined and resigned, that post cannot be filled up.
Item number 2.
Item 2, my lord. Just now I received counter affidavit.
My lord, item number 2, I am appearing on behalf of the university. Their allegation in the
Just one moment. Where is your affidavit? You'll give it. Yesterday you said it is ready. You have filed.
File it in the registry.
My
Will
lord,
not
I am for the help university, my lord. I have to file counter in this case.
file your counter.
Kindly see page 14. We have already notified the date. Their allegation is direct them to hold examination. Examination is going to be held with effect from 29th.
Yes, the examination is going to be held then.
Therefore,
what
the
for?
repetition is not.
Yes, what?
I'm the health university, newly formed the health university manager.
Yes.
At the old university, they are conducting the case.
So you fight outside the court. Have you filed? Do you have grievance against the university?
No, I don't have any. But I should, the grievance is against us also that to conduct the examination. Examination is going
If
to.
they want examination and examination is going to be held, then what is the problem?
No, I don't have any problem, ma'am.
All right. Heard that
I don't have any
on behalf of the petitioner and the opposite parties. So this writ application has been filed seeking direction to the opposite parties to conduct semester examination in BSc bracketed optometry. BSc optometry bracketed BO it is the grievance of the petitioners that till date no examination has been conducted out of 8 semester examinations. So an affidavit has been filed on behalf of the which university is this?
Opposite University.
Behalf of Maharaja Sri Ram Chandra Bhanjar Dev University, Mayur Bhanj, to which the college, which college?
It's
Biju Patnaik College of Barikuda.
Biju Patnaik College?
Biju Patnaik Medical Tech. What is this? Biju
OP4.
Patnaik Medical Technology. That is a college.
OP4. Yes, OP4.
There has to be
Biju
some
Patnaik
college
Medical
institute or something. So careless.
Has fixed dates for such examination. First of the examination is going to commence from
29th August.
29/8/2024. First of, in such view of the matter, it is the petitioner's contention that his grievance has been redressed. First of, there appears to be no dispute that the college का pronoun was affiliated to the university.
Maharaja,
University.
Sri Ramchandra Bhandev University, opposite Pannur 3 University.
Mr. What is your name?
My name is Norajit Pradhan. S. Pradhan.
Mr. S. Pradhan, Learned Council has submitted
Appearing for Odisha University of Health.
that University of
Health Sciences.
Health Sciences has been established.
Established in the year 22 and 21 and
What is the effect of that, Mr.? What is the effect of this establishment of this university?
My lord, what has happened? They are now reading in the opposite Pannur 3 University. And it is our duty to conduct the examination. And as per the program, we have already issued the program.
No, but whether your exams will have any value or not.
Yes, my lord, that
Yes,
they will have.
My lord,
That they will have.
That they will have.
That they will have.
my lord, they have got the NOC and application from that time when that was released.
Appeared for Health University. So, in such view of the matter, this application, these are two, there are two applications.
Two applications.
Two applications are different. subjects, my lord.
Different subject.
The other one is
The
medical
application is
radiation technology.
Next is BO.
Medical radiation technology, the last one.
Subject का नाम बोलो. Medical.
Radiation technology.
Medical radiation technology.
BSc in medical radiation.
See medical
Radiation
application technology. Affidavits have been taken on the
I am for the DMT, my lord.
PMA.
My lord, I am for the University, Health University.
Yesterday's matter,
You were supposed to go through that judgment.
he was supposed to. My lord. My lord. In this judgment, that the appellant is a municipal governing, municipal local body. This is not government authority. And observation part starts from para 32 million.
Decision order. Decision order. Judgment. Data.
Yes.
Upper
Hello.
language.
My lord, in para 36 of this judgment, last for undue delay, the blameworthy conduct a person in approaching a court of equity in England for obtaining discretionary relief which disentitled him for grant of such relief was explained. But here in this case, Miller, after death of my father, immediately I have applied. In the year 2004, thereafter, Miller, repeatedly I approached to the authority several times, and more particularly since 2009 to 2015, Miller.
Forget this decision. What
Miller.
is your, in the light of this decision, what is your argument?
In this,
He died in 2003,
my lord,
2004.
2004, I
We are
have
in
applied.
2024.
My lord,
You, in the meanwhile, survived.
my lord.
Whether you were or anyone in your
Miller,
family.
in otherwise, I compelled to survive, Miller. In otherwise, I am compelled to survive.
Then if you could survive, then
Miller,
there is the question.
Miller, of this
Yes.
judgment.
Yes.
Para 60 says that in fine, the present appeal succeed on two counts. First, there was no policy existing to govern compulsory appointment to post under local authority. This is a separate case. This is a local authority, not government authority. In the state of West Bengal, and hence, in the absence of such a policy, compassionate appointment cannot be granted. Second thing is, assuming that there was such a policy, it would be for redeeming purpose to direct that the application for appointment on compulsory ground be considered and decided several years after they were filed. But
As relates to filing my application, I have immediately filed. Thereafter, several times I approached before authority. And finally, when amendment rule commenced, I immediately filed a RTA application that please search my application. They have misplaced my application. On the basis of RTA application, first appeal conducted, and additional director to the secondary education also directed to the DO to consider my case. This is the fact, my lord. On each and every stage, I have approached to the authority.
All right, we will decide.
I will see. In this case, I have challenging the order dated 1/2/2024 under annexure 2 lordship. Annexure 2 lordship, where the learned honorable single judge has confirmed the revisional court order dismissing the writ petition lordship on the ground ground lordship deletion the name of mother of the parties from the tenant column of the ROR is well and justified, lordship. Lordship, kindly see the order dated 1/2/2014, page 23, para 4, lordship.
Yes, please.
Smile. The admitted facts remain that one Busabha Pradhan was the common ancestor of all the parties. Busabha had 3 sons, namely Trilochan, Tuladhara, and Bhagavan. Busabha died in the year 1955. Your Lordship, Busabha died in the year 1955. Then, in 1965, his 3 sons amicably petitioned, Lordship, the entire property of Brusabha and possessed their respective share separately. Lordship, Brusabha was died 1955. In the objection petition before the divisional court as well as before this honorable court, honorable single judge, Brusabha has 5 children. He had his wife and 5 children, not the 3 sons only, but the amicable partition between the 3 sons only excluded the daughter Lakshmi and Tilotama and his wife also. One sealing case bearing number 61 of 75 was initiated on the properties of Brusabha. The land is the sealing surplus land. Prior to the initiation of the sealing surplus land, the land is the government. Prior to initiation of the sealing surplus land, the land with the government, Brusabha has no recorded tenant holder. Who
are you?
I am for the appellant lordship, the legal heir of the Brusabha.
So what is your grievance?
My grievance is,
there was a family partition in 1965.
my lord,
This is an admitted position.
my lord.
So this is what the learned single judge has noted that after the partition, they enjoyed the property separately. And therefore, what is wrong in the finding? That being an admitted position, then what is there?
The land is not the owner is not the Brusov is the land lordship. Prior to the ceiling surplus land lordship.
All
Prior to the ceiling surplus.
All right, we will go through your petition and then
Yes.
difficult to. What is the case?
Here, in fact, he is claiming that in addition to 3 sons, there are 2 sisters or daughters. They were not given, sir. In that event, the settlement was in 65. They claim never filed any suit. Now they come up saying that it should not have been confined to 3 sons, 3 partitions. It should have been among 5 co-sharers. And the revision authority and the revenue authorities all have concurred with the finding that after the settlement, the land should be recorded in their name. And the second thing is that it's an application under 227. Writ appeal is also not maintained. We are not under 226.
How do you say it was under 227?
Because it's a cessionary proceeding. He is challenging the order of the revenue authorities, revision authority. It's a cessionary proceeding, not Article 226 lordship held that.
Certiorari proceeding, all the proceedings are certiorari. If you challenge an order of dismissal, that is also certiorari.
Normally, 226 power is invoked, like read jurisdiction. Then writ appeal is maintained. It's a proceeding under 220. But some cases of this also held that the 227 proceeding, writ appeal is not maintained.
If we hold that a writ appeal will not lie against an order passed by a learned single judge dealing with an order of the revenue authorities, then see, there is specific provision in Allahabad High Court rules. There it is not maintainable. In Bombay, the position is different.
Of course, our rules not done.
In the rules, it is not, and because it was a certiorari proceeding can be initiated against any quasi judicial order.
Right,
so we may not interfere with on the
We are
ground
slow in interfering, not
on the ground of concurrent finding of facts by the revenue authorities, but to hold that it was a proceeding exclusively under 227 and not under 226 is difficult. Because certiorari proceedings are under 226.
Right, no, that is true.
I am for the restaurant number 3.
Mr. Misra, paragraph 5 of the order.
My lord.
You are saying you are the legal heirs of the 2.
Legal of the Brusov Pradhan.
No. Sisters. But paragraph
They are
5
not-
says you are the LRs of
They are not
Trilochan
party
and
to the any
Tuladhar.
proceeding.
Just one moment. That you are the LRs of Trilochan and Tuladhar. So is
My
that
lord.
correct or not?
My lord, correct.
Because Trilochan and Tuladhar are the brothers.
Trilochan and Tuladhar lordship.
So what I have understood from the order, so Brusova, so it was divided for 3 sons.
3 sons.
3 ceiling limit, 3 sons. But name of mother was recorded in the ROR of 1 brother. So he came up challenging that entry, saying that should be deleted.
Well,
And that was done. Thereafter, you being the, say 2 brothers or the descendants said that since her name was recorded, we have a share in that brother's property. So where do the sisters come from?
no, my lord,
No, this I'm reading from the order.
I have not been allotted any land lordship.
Then this,
The only land that is the whole land lordship allotted.
No. Because paragraph 5 says, present petitioners who are the LRs of Trilochan and Tuladhar
My lord.
claim that they being LRs of Mandodari are entitled to the respective shares in respect of the ROR where the name of Mandodari was recorded along with the name of Srimati Pradhan.
My lord. Mandodari is the mother of the parties, is all parties.
I understood. So mother and sister's name was recorded.
Mother the daughter's name has not been recorded in the tenant column of the RR Lordship. Only recorded in the name of Mondodari and Tilotama Lordship.
Dead at the time.
Srimati Lordship.
But what is the genealogical table?
The wife.
Let us understand. Brusav.
Miles. The as per
Brusav and
Brusav died in the year 1955 Lordship.
1955.
My lord.
So he had
3 sons.
He has a wife. Wife Mondodari
Yes.
died in the year of 1991.
3 sons.
Thereafter, 3 sons, Trilochana, Tulodhara, Bhagavan.
Tirulochan.
Tulodhara, Bhagavan.
And Bhagavan.
Turadhar.
Bhagavan.
Bhagwan.
And 2 daughters, Lakshmi and Tilotama.
And who is Srimati?
Srimati is the wife of Bhagavan.
Okay.
Who are the petitioners?
Petitioner, Srimati is the petitioner in the revisional court, and I am in the petitioner in the read court lordship, single judge lordship.
Who are you?
I am for legal heirs of the Rusava,
Legal of Tulodhara
Tulodhara and Tulochan.
Tulodhar
and
Tilochan.
Tilochan
And what about Bhagwan?
is the recorded tenant who is the respondent number 3 lordship,
Respondent is the wife of Bhagavan.
wife of the Bhagavan lordship.
Bhagavan dead.
All right, we will hear you tomorrow. We'll see the file first.
My lord.
You wanted extra share from one brother.
No, my
What happened, my lord, in this case, my lord?
We'll come back tomorrow. Huh. Tell us tomorrow. Just
Item 6 also same.
5 and 6 both, not, 2 writ applications, 2 judgment.
Yes.
Item number 7.
May please, your lordship. The appellant, my lord, being the petitioner, has preferred the writ petition challenging the impugned advertisement issued by the OPSC on the ground that it has not complied the UGC regulations, man. Before I take the facts of the lordship may kindly permit me to place 3 paragraphs from the writ petition, man.
So let us see the order.
That is at page number 104. And relevant page 105.
Come to paragraph 5 of the order.
Yes, madam. Then its senior counsel appearing for the OPSC on the other hand contended that the advertisement has been issued in terms of the provisions contained under Odisha Fixation of Upper Age Limit Rules 2020. It is also contended that the petitioner in terms of the advertisement has neither made any application nor he has challenged the same prior to last date, which was fixed to 20th of February 2024. Then, having heard the learned counsel for appearing for the parties and in view of his
So what
submission,
locus do you have?
my lord,
What locus do you have to challenge?
well, so far as the age criteria is concerned,
So you could have challenged. So after everything was over, you challenged it.
no, after the last date, before the last date, I have challenged, my lord, on 28th itself.
Why 28?
Because, my lord, the petitioner,
Prior to last date, you did not challenge.
no, my
So you waited for the, when was the advertisement issued?
advertisement was issued on, my lord, (29 12 2023).
29.
12 2023.
So you have the application has rightly been dismissed. You filed the application 2 months after that. You don't have
I-
the first hand, right?
I filed the writ petition on the last date, my lord. Admittedly, I filed on the last date.
Therefore,
Yes, my lord. But I had approached the authorities. I was hopeful that a corrigendum will be issued to that effect, but there was not.
You had
Another advertisement was issued.
that you had approached the authorities. Is there any document to
No,
that
no, my
effect?
lord. That is not there.
The-
That's why I approached the report on light of the application.
appellant had put to challenge the terms of advertisement number 23 of 2023-24 dated 29/12/2023, inviting applications for appointment
The post of lecturers, madam.
to the post of lecturers.
Assistant professor.
On the ground that the same were not in conformity with the UGC, University Grant Commission regulations on minimum qualification for appointment of teacher and academic staff in university and colleges, and measures for maintenance of standards in the higher education 2018. This was stop. The advertisement, the last date for submission of application against the advertisement was 20th February 2024. Stop. The appellant filed the writ application on 20th February 2024, challenging the said advertisement. Stop. Learned single judge has dismissed the learned single judge of this court by an order dated 26/2/2024 dismissed the petitioner's writ petition, that is WPC number 3898 of 2023, mainly on the ground that he challenged the terms of advertisement nearly 2 months after the date of advertisement, that is 20th February 2024, which was the last date for submission of application. So, next, learned counsel appearing on behalf of the appellant, assuming the impugned order passed by the learned single judge, has submitted that the appellant had been approaching the authorities with a request to amend conditions of the advertisement and issue corrigendum accordingly in consonance with the requirements of the UGC regulation. First off, as no corrigendum was issued, the appellant was compelled to approach this court, though on the last day or last date fixed for submission of applications. Stop. Next, then counsel for the appellant has, however, not been in a position to draw our attention to any material to suggest that before filing of the writ application, he had approached any authority. Stop. Authority raising any grievance against the terms of advertisement. Stop. In such view of the matter, we do not find any legal infirmity in the impugned caused by the learned single judge refusing to entertain the petitioner's writ application, challenging the terms of advertisement on the last date fixed in the advertisement for submission of application forms. So we do not find any merit in this appeal, which is accordingly dismissed.
Item number 8.
Yes.
May I please? This is regarding that
appointment under rehabilitation assistance scheme of a doctor was applied after 7 years of the death. That question, Your Lordship, has heard that matter. And Your Lordship, after going through the judgment of the Tiwari case,
Yeah.
that the limitation part,
Which judgment?
that yesterday that Devadutta Tiwari case,
Judgment is available.
State of West Bengal versus. The judgment of yesterday that was
Yes, yes.
2023 SCC online, Supreme Court 219. Your Lordship asked me that in view of that judgment, how that rule is, that in our rule that on attaining the age of majority one can apply, but in that rule, in that by flux of time one has lost its right for appointment under rehabilitation assistance scheme. And that has been taken care of in 2020 rule. 90 rule was repealed in 2020. In 2020 rule that we have taken care of, those who have applied in 1 year, their case will be considered. So far as that 18 years, that is not provided under the 2020
That
rule.
minor thing you have removed.
Yes, yes. Only 2 years maximum is given.
But according to all rules, you had given that.
That 90 rules that was the provision.
You had given that.
Second. 90 rule, that is the provision.
Right.
Only aspect Your Lordship has seen that the certificates here submitted, that medical certificate that in the year 2013, the death occurred in 2007. At that point of time, mother as well as daughter was minor. Admitted fact, mother was there. Mother was 40 years old at that point of time. She did not apply. If Your Lordship will go through that rule, if no one is available on attaining the majority, she can apply.
The interpretation of that word, no one, whether mother can be taken to be somebody who was eligible to be applied. So
Yes,
that-
my lord, that if Your Lordship will see that rule 2B mother is included in the family members.
No, that is all right. But some, we have to
That-
consider
that's the
somebody who
interpretation.
was, who could have done the, could have been appointed.
Yes, madam. That is my lord's.
मिळला जजमेंट मिळला खाली देशील report दिया है.
Well, I am giving that.
पूर्व केस में like it was see it is there in the previous file 244.
Huh?
Which both are the same principle.
I am that giving that.
Having it.
Item 4 ଥିଲା ସେ judgment.
से previous ପାଇଗଲେ ତ.
No, that I have given my I have given my copy.
Say previous that
Item 4
244.
Yes.
সেটা পড়ে You have only one copy.
I have given that.
Correct.
How many such matters are pending?
Like this.
Minors.
Minors, few met, not one.
There may be two types. One minor is applying after so many years and
In
somebody
in that case, government has considered.
where only minor is. the
Only
only-
minor, that case, that there is no dispute about it.
Here also,
Here, minor, where minor and mother both are there is the dispute. Some type of disputes are there.
Well, this is a small thing.
But that's Your Lordship.
we can understand other. Mother,
That I have said that my lords for consideration because this is a rehabilitation assistance scheme, I cannot.
All right, we will consider pass orders.
But one aspect your lordship may consider because the present status it
No, no, we will say that this will.
no. What I want to say, my lord, the present status of the if the family income of that lady is now.
you mean to say in the meanwhile, if they
Yes,
have,
but that because in the meantime, 14 years have elapsed. If that economical capacity of the family has been developed in the aim and objective only to
what is the
to mitigate the hardship of a distressed family.
what is the daughter's age now? 18, 19?
30,
Uh-huh.
20.
Now it is 30 something.
Yes, my lord. In 20,
Delayed for so long.
30.
30. Must be married and
Yes, many factors. My lord. And another aspect, my lord, that 2020 rule has come into force from 17 to 2020. If your lordship will consider it as a pending case, we have to reconsider it. Then it will come under the 2020 rule. But under 2020 rule, he will not be covered.
No, don't interfere in peculiar facts and circumstances of the present case
Well,
with an observation that it shall not be treated to be a
my lord.
That can
But-
be done.
But only consideration the status of that lady, because in the
the
meantime,
status has changed
Poor-
because you
poor.
delayed also.
if that is changed, then
No. When did she apply?
she applied in 2013.
13. But it has remained pending for so long. So now if you
Your
consider
lordship may
status,
decide.
she has to live.
Because
May not accept the job. You'll give class 4.
yes, she has applied for class 4.
So how do we determine the present status?
Suppose she has married to a
No,
good
not
officer
not yet married, your lordship. Not yet married.
or employed elsewhere.
No,
I don't know his status
nothing
at present.
Not employed.
Not employed, your lordship.
Your lordship may decide.
Tomorrow, she has come with me. Day after tomorrow, she
File an affidavit.
day before tomorrow, she has.
Day before tomorrow is tomorrow. No,
No,
day before
day-
tomorrow is today.
Day before tomorrow. She has-
Day before tomorrow is today.
Day,
Day before tomorrow is today.
sorry, day yesterday, tomorrow. She has come with me.
So
We
you
got
file
discuss
an
about
affidavit.
the,
You file a short affidavit
yes, your lordship.
disclosing the present status.
Yes, your lordship.
And grandmother was there. She must have expired.
Grandmother,
I have requested
only
of the
mother and
opponent list this matter on 1 week
Right.
for retaining its position.
Give an affidavit.
yes, your lordship.
About mother also you can take an affidavit.
Item number 9.
Yes.
Yes. This matter was there yesterday. A sealing proceeding was initiated against.
No, you were referring to the definition of land. So are you satisfied now?
Yes, I am satisfied that it is covered. Lords will kindly see. Let me just.
That covers urban
place-
land also. That covers urban land also.
Also, unless it is used, it is for the homestead purposes. Unless it is a house and homestead.
Master, there must be so many judgments on this
I'm
point.
just now,
Defining land. and
I am
homestead.
just now taking to your lordships few provisions of the act. Your lordships will consider that. The sections are clear. Your lordships will kindly see.
Now, please come to the object.
Object. Yes,
So the entire act is for agrarian reforms.
Yes, whereas it is necessary to enact a progressive legislation relating to agrarian reforms and land tenures consequent on the gradual abolition of intermediary interest, and whereas it is expedient to confer better rights on agriculturalists to ensure increase in food production in the manner hereinafter appearing, is hereby enacted by legislature of the state.
Agriculture is at the core.
Yes, always. Yes.
So what is wrong in the order?
Let me explain the scheme of the act. Section 37 capital A speaks what is a sealing area.
All right. So this order was passed when? The order impugned was passed when?
Well, order impugned was in 2019.
And why are you challenging in 2024?
But I came to know now. I came to know of this now because after following the assembly proceedings and the other newspaper items, I could know that such a vast land has.
So have you stated that you
I have
learned?
Yes, I have stated that. At page 14, I have stated
Yes.
that in the process of inquiry and probing into the matter, the petitioner time and again not only had been to the offices of the Tahsildar, but also to the office of the Collector Balangir. In course of discussion about the matter, the petitioner learnt that not only that the matter was within the attention of all the revenue officers, but also was a subject in the assembly. The petitioner further came to know that before the Public Accounts Committee of the Assembly, such issue cropped up, and the Commissioner Land Reforms, who appeared committee, admitted that the
So
orders.
whether the matter is pending before the committee
Then it was pending. It is pending even now.
So when did you get the impugned order?
Concluded.
When did you get the impugned order?
Impugned order, I got the certified copy now.
When?
In 2024 only. Copy together. Sometime in 2023 only. But the question which I am trying to raise before your lordship,
Mr. C.
Yes, I understand.
There are 2-3 questions. You are challenging an order of Tahsildar.
Yes.
In a public interest litigation before the High Court.
Yes.
If you had remedy, you could have availed.
Yes.
If you had no remedy, it's a different matter.
I don't have a remedy because I don't have a remedy because I am not a person aggrieved as defined under the Act. It's only the person aggrieved can file an appeal. Person aggrieved is the state. They have not filed any appeal. And it matter as I was placing before lordship, assembly and the questions were going on and state has decided to file an appeal. Thereafter, they have not filed an appeal. And I have.
So therefore, we are bound to decide.
I am on a question, my lord. A proceeding will be initiated on the basis of a draft statement. Whenever a sealing after the act came into force, then.
No, Mr. After act came into force, that act relates to agricultural land only. How are you clubbing the urban land? Why? On what basis?
No, urban land has been defined, my lord. Homestead is defined. It's not that I am clubbing it.
Yes.
Just let me, your lordship permit me. Your lordship permit me to place one provision.
Yes.
Thereafter, things will be clear. Section 39. Principles for determining the sealing area.
And do you have any judgment on this point that this provision does not apply to urban land?
I have one decision, my lord, 1977 CWR.
What is that?
Just now I got the copy of that. Thoroughly I have not gone through, but
Please
that
go through. Go through it. In fact, we will hear you. Already, we will address the point which you have which you have raised. You will see. Plus, please examine first. We are of the prima facie view that this will not apply to urban land. This provision.
No.
And there are decisions on this.
Again, there are constituent land and there are also agricultural. There are many agricultural land, there are many houses.
So the definition is
Even in urban area, my lord, if the land is agricultural land, it is covered. It will, but as your lordships have rightly pointed out, the purpose is agricultural land.
There are two things. If the land is somehow or the other connected to agriculture, that falls within the meaning of the land under the
homestead.
But if it is in urban area, then it's a different thing.
No, in urban area, if suppose agricultural land is there, that comes under this act. There is nothing called rural or urban area. All agricultural lands are covered under the act. If in the urban area, if it is in homestead land or house or any other thing, definitely it will not be taken into the purview of this act.
We will consider.
That also ceiling is there. Up to 3 acres only such an exemption.
So we will consider it later. We'll consider it later. It's not such an urgent matter that.
In fact, your lordships wanted to examine if notice is required to be given to the state to find out whether they have filed an appeal or not. If lordships direct, they will let them give that instruction.
Let us see the provision of appeal.
Appeal, section 44. Just one second. 44 subclass 2. So it reads, any person aggrieved the same within 30 days from the date of the order. For the state government, it 30 days from the date of the order.
Where is the order? Where is the provision for appeal against the order of the Tahsildar?
That is one. An appeal against an order of revenue officer. Revenue officer is Tahsildar.
Where is that? 2.
Yes, 2. Subsection 2, Miller.
Confirming the statement.
Yes.
Who is the person aggrieved? Is there any definition of person aggrieved?
Yes.
You are also a person aggrieved. There is no such definition.
There is one judgment, my lord, in 82 CLT, which says that persons who are aggrieved and have been claiming a separate ceiling are the separated members of the family. So I do not belong to the family. So as your lordships are rightly pointing it out, an appeal I could not have filed an appeal because my grievance is if the excess land is there, that could have been given to the
landless. Public are deprived. And one person is holding the land. Therefore, interest, for that public interest, I have.
No, there you may be right.
Right. So, if who are the person aggrieved in respect of that proceeding is only the person who is entitled to.
No, but see, Mr. You're the conduct of your client. You are saying that you got the certified copy in 2023.
Yes.
Certified copy was issued in 2019.
That is the order. When it was
No.
Was it issued on 19?
That last page may not be there with you. You have given it from the original we are seeing.
Just see. This is not the proper conduct. And you are filing this writ application in 2024.
Yes. 2009.
This is not fair. This is not fair. What is this matter after 8 weeks?
Item number 10.
Please find out. Please work out. And you please also work out.
Yes.
What is the... we are not very happy.
Let's
The
as I
See.
mentioned, my lord, things
See,
were in the committee.
the Land Reforms Act, no, I don't know about in most of the states have failed. And every one of us know why.
Yes.
But still, this is not the way this matter ought to have been conducted.
Well, I'm in fact shocked to find that in the absence of a draft statement, how the proceeding is done.
So you could have approached some authority that this has happened. So you are in 2019, you are getting the order. You are saying you received the order.
Things were under discussion in the assembly. The revenue office, the commissioner was called there. And he has also admitted that, yes, there is wrong and we will move the appeal.
All right.
Question item number 10.
Item 10.
You also said direct to file the affidavit, also counter affidavit. Counter affidavit is being filed today through e-filing. I've got the copy. I'll serve a copy to my learned friend. I'll also may take it up when it's sometime.
You're filing today.
I record that. Today I filed it through e-filing.
Learned AGA states that a counter affidavit has been filed today. Online. A copy of which has been served upon learned counsel for the petitioner. Also, as requested on behalf of the petitioner. How much time?
Next week,
2 weeks' time is allowed to consider the said counter affidavit and file the rejoinder if required. 2 weeks.
Item 11.
Mission item number 11 here also Lords directed me to take instruction in the matter. This is regarding encroachment by some of the millers, vendors of a road millers in front of the medical college and other things. I've talked to the Tahsildar. He was supposed to come with the instruction and other things. But due to that Bharat Bandh picketing, he could not come millers because he is in executive magistrate duty. Here he has stated that there were some millers encroachment and initiation was there for removal. And they've approached some authorities, there was some order. So I pray only next week, also may take it up with the so that
Requested on behalf of the estate, lets this matter on 2 weeks for him to seek instructions and file affidavit.
Item 12.
Under item 12, the government has taken time to file the counter, and the opposite party number 2 to 12 took time to take instruction.
Who are two to 12?
The dean of the government colleges,
This is about what?
director of medical education, government of Orissa.
This is regarding what?
My lord, I am for DMT and for OP number for additional DMT, my lord. I have got the instruction that I will file the counter. This is a sonologist, radiology department, sonologist training. There is some allegations that I will. 2 weeks time may be given so that I.
SCB Medical College.
Yeah, he has alleged in all the medical colleges.
In the state of Orissa.
What?
That allegation is the doctors are not there, professors are not there. They are getting the training.
Is it that case because of that training, the professors are
Infrastructure
not
or
able to do their
faculty?
normal work?
Yes.
That is this case, right? Item 11, you not filed your appearance memo. Item 11,
Item 12.
12,
I have filed my what
you filed Aji.
I have filed.
Nagu de diyeceğim. Nada action. Counter you file today.
Yes. Counter not filed.
And is there any strike in the hospital?
Pardon?
In the
Strike of
hospital, whether there
doctors,
is.
Mr. Samantre?
Yes.
Doctors strike.
I think
Has
now
it been
they
called off after the order of
or
the
not
Supreme Court?
officially called up, but OPD is not working.
No, junior resident doctors?
I think they're not officially called up this strike as yet now. Because take it up 2 o'clock, I can obtain instruction and
Train instructions.
Yes.
2 o'clock we will take up. And 2, whether the teaching posts are vacant or not.
No.
Who can say?
My lord, in this case, already they have taken admission. The course is going on. People are getting training.
No, but what about the post of assistant professors, associate?
Professor, they are there, my lord.
They are there
In the 3 medical colleges,
in 16 medical colleges.
there are professors in Department of O1G, Department of Radiology. They have given the list to me. I have
Not only radiology, all the
Radiology.
departments. We will take up the matter at 2 p.m. In the meanwhile, you please inquire about the this strike issue, and at 2 p.m. we will pass an order for you to produce before us the latest position of vacancies in all the medical colleges in the state.
Are you aware if any litigation is pending regarding the appointments for which you have not appointed? That also information give us.
Fine, sir.
Or DMT has nothing to do with.
Now, DMT has given the allegation is DMT has given an advertisement for DMT's advertisement. They have applied and they are continuing. The allegation here is that the most of the areas there is no infrastructures, no instruments are found, no professors are there. But today,
Professors there and the existing professors are going to give training to other courses for which their education is suffering, right?
Yes.
Yes.
But I have got today morning this thing. They have given the status of the professors and assistant professor of the medical colleges.
For which all the colleges?
All most
Let
of
us
the colleges.
let us
They are given.
let us.
Is the one copy.
Have you stated about this in your affidavit?
No, I have not filed the affidavit. Today morning I have got, so I was taking time for filing the affidavit.
But you said today? So
No, today I have filed my Vokalatana.
Oh, you understood you're going to file today. This is, I think 2-3 dates have gone.
Today morning I got this after getting this.
1 day, 2 dates. You were supposed to file a counter affidavit. This order has been passed in May. Item.
These colleges should be closed then. ONG,
That is
obstetrics and gynecology. Why only two departments?
Two departments. They have sonography is in two the departments they have to put.
All right, we'll take up at 2 p.m. In the meanwhile, please inquire.
No.
Item 13.
My lord,
Ramandra, in this
it
case,
pertains to-
last indulgence, so check.
Yes, sir. I think there was a public rented litigation wherein not, so I think that is whether that's been pending or sir, your lawsuit said ask the state government to give the vacancies in all the medical colleges in the state and whether it has been filled up and if not, why? So
Give us.
I'll try to find out that PIL, my lord.
The one PL was there, he made such a commotion that we had to send it to another bench.
Yes.
In item number 13, my lord, the state was asked to file the counter affidavit.
Lordship, we need 2 more weeks' time to file a counter.
How much?
2 weeks' time.
2 weeks. Further time is allowed for the state to file counter affidavit. This is on 2 weeks. Yes.
Item 14.
My lord, matter relating to granting need by the shape of law grant order, virus is which was hard and judgment deserved. My lord. Let it come, my lord. We take
To list this matter on 2 weeks, awaiting decision in. Do you have the number?
Matter which has been heard, do you have
Yes,
one?
madam. Already heard, not this matter. The
We
batch
have
of matter was
understood,
hard.
we have understood one number of that batch.
My lord,
Or the lead
I
case.
will provide. I will.
All right.
2 weeks.
Item 15.
And please, my lord. My lord, this is a PI, my lord. Here, the opposite parties have identified a spot for construction of bus terminal, my lord. The difficulty is, my lord, that a natural channel was flowing over that spot, which is and carrying rainwater to the paddy field of the villages, my lord. Our limited grievance is that, my lord, prior to construction of the terminal, an alternative arrangement should be made to passing for the free flow of that rainwater, my lord. And to that effect, I have also already given a representation, my lord.
File your affidavit.
Yes, your lord.
When did you file your representation?
Post has gone,
Representation, my lord.
9/7/2024.
No.
And petition.
Up to 10.
18/7, your lord.
18/7. 18.
What should we do?
We should have waited for. The rule says after 60 days, my lord, but
So
due
you
to
file
rainy.
your representation was sent through post.
Yes, my lord.
Registered
All
post is given that.
We are imposing cost for this.
We have also made, my lord, given representations.
We will take up. We can take up the matter suo moto, but we will dismiss your application with cost. The
My lord, due to rainy season,
present rate application has been filed, seeking direction to take action on the petitioner's seeking direction to opposite party number 2 to take action on his representation. Stop. The representation was filed. The representation 9/7/2023 24 24 as communicated to the opposite party number 2. Stop. The petitioner filed this public interest litigation on 18/7/2024, 19/7/2024, seeking direction to consider the said representation. Whether the representation was received. Whether the representation was received.
Lord, it must have been received
The
because it proves.
petitioner has no information as to whether the petitioner's representation was received by or not. Stop. In our considered opinion, filing of the present writ application for disposal of a representation within less than 10 days from the date of filing of representation, date of sending the representation, is a misuse of the process of the court, misuse and abuse of the process of the court. Stop. This writ application is accordingly dismissed with a cost of rupees 10,000 to be deposited by the petitioner in the account of High Court Advocates Fund.
Pardon, my lord.
Yes, what about Madam?
Yes, Your Lordship.
Because of the cause
I'll seek instructions, Your Lordship, in this matter, and I'll intimate Your Lordship's intention to the department, Your Lordship.
matter on 2 weeks, 4 weeks, let an affidavit be filed on behalf of the respondents, opposite parties in the meanwhile. This is not done. You should never do this in future.
I will take care of the license.
Item 16.
Item 16, my lords, here the petitioner challenges annexure 1, page 12, my lords, whereby the authority, the opposite party's medical hospital, has floated a tender for supply of orthopedic implant, my lords. My lords, wide annex 2, your lordships will see page 20. There was earlier an advertisement in the month of January 2024, and the present petitioner has executed an agreement for 1 year.
I think if I remember correctly, we had asked you to tell us what were the articles covered.
The price list, my lords,
What were the articles covered? Whether these implants were also covered in the previous.
my lords, I have done a memo, my lords.
Memo? Why memo?
Well, the present petitioner was supposed to come today, but due to this Bharat Bandh, the bus could not come today morning, my lords.
Day of 1 week.
Lords, can it be tomorrow, my lords, or day
1
after?
week.
Urgency.
Well, the urgency is that they have opened the tender, my lords.
We'll see.
Item 17. Item 17.
Next week, my lords. Great.
Your Lordship. The petitioner hearing, my lord, seeks to challenge the order under annexure 15, my lords, wherein the petitioner has been, my lords, blacklisted, my lords, for a period of 3 years, my lords, by the opposite parties, my lords. And the petitioner further prays, my lords, that
page,
my lords, annexure 15, your lordships will find, my lords, at page 88.
Yes.
My lords. Now, the factual backdrop, my lords, of the case, my lords.
It has been filed.
My lords, the
First time.
My lord, this is first time.
On what grounds are you challenging? Because it is on fact that you withdrew after the LOA was given to you.
Yes, I'll tell your lordships. Now, my lords, the bid, my lords,
Shortly, just one line.
one line, my lords. Now they have taken the decision to blacklist me after more than 1.5 years' time, my lords. In the month of February, recommendation was sent. So cause notice was issued to me in December 2000. I replied to the so cause notice, my lords. Thereafter, in February, there was a recommendation. February 2023, there was a recommendation to blacklist me. Now the show cause reply to the authority to whom I filed, my lords. Another, my lords, same authority, my lords, but the successor has taken a decision after more than 1 year period time, my lords. And my lords, and my reply to the show cause, my lords, has also not been taken into consideration. And this has happened after, my lords, the letters under Annexure 12 and 14, wherein, my lords, the DPI, the Chief Engineer Roads, writes to the government, my lords, that now, since more than 180 days have elapsed since the date of blocking my portal registration, as well as I've not been blacklisted for more than 1 year now. So decision may be taken to unblock me as well as I may not be blacklisted. Thereafter, immediately, my lords, this decision has been taken. The impugned action has been taken under Annexure 15. If you're for your lordship's convenience, if I may read out only Annexure 14 for a moment. Annexure.
Yes, file your affidavit.
Ma'am.
4 weeks.
Ma'am.
This is considered on. So it's renewable and counsel for the state file a counter affidavit.
Just pray, my lords, that the difficulty now that I'm facing is because of the blocking of my portal.
After 4 weeks, make a mention.
Item 19.
Your loss. Here in this public interest litigations, the villagers have agitated. Villagers have raised a question of functioning of crusher unit other than the permitted plot. In fact, they have represented some inward action has been taken, but thereafter, may I draw you?
What happened?
Some action has been taken. A joint inquiry has been conducted for ascertaining the fact whether the crusher unit is functioning on the plot for which permission has been granted or not. The inquiry report found more than one plot for which he was allowed to, for one plot, more than one plot is being used for the crusher unit. And also there is a clear violation of the sitting criteria. Thereafter, the inquiry report was also submitted before the assistant collector, who in turn wrote right to the Tahsildar, revert back immediately taking action. Thereafter, it seems no action has been taken. If your lordship kind enough to have a glance over page 43 and 44, this will suffice. I don't completely attribute that they have not taken any action, but thereafter, at least their joint inquiry report shows that he is permitted to have his crusher unit over 317 by 754, page 43 I am referring. But he is operating 4 other plots, my lord, including belonging to a school for which the school has granted NOC, my lord. Of course, this is a playground. This has brought in the joint inquiry, page 43.
Has been converted for non-agricultural.
That is the only
plot. Okay.
My lord. And page 34 is the NOC. 34 is permitted for that plot only.
That is there in the report. And the headmaster has provided NOC?
My lord, headmaster. That is also astonishing fact.
High school has provided NOC for stone crusher near the school.
He has no authority, my lord. It is to say.
No, apart from authority, if it is near the school, they will inhale all those.
Yes, that is what our agitation.
Dust. Sorry?
File your affidavit. Who is appearing?
Union of India. Opinion, sir.
Union of India.
Why Union of India?
No, revenue inspector, collector.
Copy not served. Copy copy
You have not served a copy.
He must have served it.
I am serving another copy. Unless I serve a copy, it
Yes,
can't be
yes, it won't be listed.
6 weeks time is allowed for the opposite parties to file counter affidavit. 4 weeks. 4 weeks. Yes.
Correct.
Way if you come tomorrow, man, it's a very urgent matter.
Right.
This is with regard to the ancient monuments of Pandagiri, which is just in the outskirts of Bhubaneswar.
No, why is it so urgent that it should be taken up tomorrow?
Well, of course. Urgency is because there is, the encroachment is increasing to the extent of completely blocking the whole thing. Even thousands of pilgrims are returning back. Not
Okay.
having
Ask someone to make a mention on Monday in the morning.
Monday.
Tuesday.
Item number 12.
At 12, I will file a counter in this case. 12. I will file the counter because I will give the details, what are the professors, what are the students, what's not, and what are the instrument there. And as my lord wanted to know about the doctor strike, as I got the information from the instruction from DMT, strike is continuing.
Yes, strike is continuing, but the PG doctors, they are attending only the emergency duties. And so far routine duties are concerned, the faculty members are looking after it only. Officially, there is no strike has not yet been called out, and that is the present status. I have from the departments, also the principal and the superintendent is and so far as that PIL, I was saying to Lordship, one PIL, WPC PIL number 6109 of 2018, Chitaranjan Mohanty versus State of Orissa, this was the issue with regard to that vacancy position in the throughout the state, with regard to doctors in the peripheral area, so also the doctor in the different medical colleges. If that is pending, you can again verify it and
Number of
WPC PIL 6109 of 2018.
So why are the doctors on strike?
All India, it's a call by the All India Nurse Association. That's why throughout India, they are all on strike. And this association, they are following.
Indian Medical Association, IMA.
yesterday, Supreme Court issued so many guidelines and so
Yes,
many.
Supreme Court is already
Yes.
And the principal consumer said that there is every likelihood that it may be called up within a day or two because Supreme Court is insisting of the matter. But emergency duty, OPD duty, that is not being looked after now.
So where is the order? Earlier you were directed to file affidavit.
No,
in
my
this
lord.
case.
I have first time I have appeared today and filed my Uklatnama. 2 weeks time may be given to file the counter.
And who is representing you? You will
I will
state.
represent the DMT and additional DMT because we have issued the notification. And I will justify why and how we have given this.
State had been asked to file counter affidavits on 3 days.
Not filed, 2 weeks time.
3 days and last date it was said without fail.
I will file within 2 weeks.
Let separate counter affidavits be filed on behalf of the Principal Secretary Health.
Yes, ma'am.
Principal Secretary Health, Government of Odisha and DMET stating the status of vacancy positions of faculties in following medical colleges in the state of Odisha. SCB Medical College. How many medical colleges are there?
Nine medical colleges.
Government college.
Government college.
9 medical college.
Following
Government medical college.
medical college, all the 9 medical colleges. Stop. The next. The affidavit must also disclose the reasons for deficiencies, if any, disclose if there are vacancies against various teaching posts in these medical colleges. Stop. This matter on 2 weeks.
Mr. Samantra, then it is the junior residents who are continuing the strike. Because Indian Medical Association has called off.
The postgraduate students.
Also, so basically students.
Yes,
Okay.
Others, regular staff, they are doing the.
In addition, DMET shall be required to file affidavit dealing with the averments spent in the writ application paravides.
Special
Item number 18.
Special list, Your Lordship, of fixed on matter 2 o'clock.
A special list, item 1. May I pray, my lord, this matter may be taken up next week, any day except 28th. Because Advocate General will address this matter.
On 28th.
Except 28th.
Keep it to September first week, coming same matter.
September 1st week.
In some cases, I have entered caveat.
At 2 p.m.
But copy of the petition has not
I'll verify and I'll serve the copy.
At 2 p.m.
Whenever you want.
Yes.
As requested on behalf of the parties, these matters on 4th September. Okay.
The other matter, let's remember that contractual teachers, that we have filed affidavit in many cases. Some cases, somehow they have not turned up. But I suggest not subject to lordship acceptance. In those cases where affidavit has been filed to delete the portion of prayer, that virus, that prayer, your lordship may close those matters so that lordship will deal with those matters. And so for the other matter also concerned, it was dealing that, those. It will be, I will give a list of those cases where affidavit have been filed. I have prepared a list also, I'll give that list.
In some cases, I am filing today. In some cases, I am filing today.
Instead of
No, but can we record your submission that you are not pressing the challenge to the virus of the.
In fact, if affidavit has been filed. to
You can
that-
file affidavit.
Yes.
But that can be.
Yes, yes,
the
yes.
thing,
But so far,
that
the other cases, those who have not come forward till date.
Even if they have not come forward, whether they are here or not.
They are
Yes.
not. No.
All of them.
Some of them are here.
The petitioner, they do not want to withdraw that first pay.
All right.
That's why dealing those cases.
Yes.
Senior counsel and counsel appearing on behalf of the petitioner in the present batch of writ applications submit that they shall not press the relief they shall not press their the challenge to the virus of which provision?
That is 2022.
Rule 4 of the 2000 contractual repeal and special provision rules 2022.
Please give us the name.
Yes,
of
give me. Yes, I'm giving.
It is noted that affidavits have been filed to the aforesaid extent. Affidavits have been filed on behalf of the parties in the following cases. To the effect that they don't intend to press their challenge, press the challenge to
Rule 4, Rule 4 of Odisha Group C and Group D post repeal and civil provision rules 2022.
Special provision.
Repeal and special provision.
Group B, C and Group D post within bracket repeal and special provision bracket 10 rules 2022.
We have heard learned counsel for the we have heard learned senior counsel and learned counsel for these parties. Parties at length. Judgment.
I'm appearing in one matter, that is 7715 of 24. I stand the similar footing to that of learned students.
That senior counsel means all senior counsel and other counsel and also.
And I have also filed 6 cases. I will give the list, my lord. I have filed the affidavit.
And I will also give the list.
Other cases where affidavit not filed, that will be segregated.
No requirement of segregation.
All the matters.
Because this order is being passed in the presence of all the counsel, therefore.
Right.
Right.
So great.
Supplementary.
Supplementary list item number 18.
Item number 18.
My lord, I have received the counter yesterday afternoon. I have already prepared.
Already it is filed on online. Physical copy I have given to. He requested me to file a rejoinder. If they file, otherwise you can take up because we have given details.
A counter affidavit has been filed on behalf of the Union of India. Union of India.
Yes, NTA, National Testing Agency, Union of India. Yes.
And counsel appearing on behalf of the petitioner seeks adjournment to consider this said counter affidavit and file rejoinder if so required. Press this matter on 2 weeks. Yes.
Next week.
2 weeks, 2 weeks.
Covalent.
সেটা भी जोड़ा है along with that special list.
Special list item number 2. Item number 72.
May it please your lordships, my lord. May it please your lordships. I am pressing my date chart and
My lords, the challenge to a proviso to the Odisha Elementary Education Method of Recruitment, Rule 97 in 2019, my lord. That is to exempt the persons or the teachers who are already there from or before 97 onwards,
Yes, yes.
after the coming of the Education Act, Central Education Act, and also there is a problem which is added to those acts that it will be a TET, teacher eligibility test, is required for the purpose of their. So TET is held in Odisha in 2012, my lord, for the first time.
Yes.
In order to rationalization, the state government passed an amendment saying that those people who are there before 2012, that they are exempted from the, presumably with a observation that it will retrospective effect should not be there. So neither the Education Act, Central Education Act has got any retrospective effect, nor, and the TET was held, and all the petitioners before your lordships, they are 2012 and thereafter they have been recruited. So the former is a class of themselves because at that time there was no TET test when their recruitment took place. They have got all the other qualifications as per the Orissa the Education Act. All the qualifications are there, but they never had a TET because there is no concept of TET at that time. That under, my lord, challenge, my lord. So, my lord, already, my lord, I've heard this matter for a long time, so I will not take a lot of time. The action of the state is under challenge, whether they can go in for a exemption clause. What is they are saying that we have exempted. My lord, kindly see the inside there is another dates and events where page 4, my lord, page 4 of this second note, my lord, which is a note. First is a date chart that provided that the top portion, my lord, of the rule that impugned rule is quoted, my lord, here. Provided that the teachers appointed against the advertisement published prior to 11/2/11, my lord, are exempted from passing Odisha Teachers Eligibility Test 1 and Odisha Teacher Eligibility Test 2. This is the notification which my lord and friends have challenged. And on the ground that this is a mandatory requirement, you cannot give a decision because our argument, my lord, is that it is both this education is both in a concurrent list, my lord, and unless there is a repugnancy of the two, then they can in the field independently, they can remain in the field. When you take up the case of these teachers, my lord, who are already appointed, my lord, kindly see, that is why I have given 9 and before 97. Their appointees of 97 and also before 97. So when they are appointed, there is no such requirement. But in the midway, when the teacher Act 9 came into force, 2009, and thereafter, NCET is the educational agency to look into this. That came in Odisha in particular date is there, my lord. It was held on. That date is important, my lord. I am just. Ah, 2012. I am just pointing out, my lord. Four 6/2012, my lord. 4/6/2012, page 2, top portion. That is the date on which the examination of TET was held. By that time, there was no TET in Odisha.
For 6/2012, in your date chart, there is no date.
Oh, no, I put it in here, my lord. Page 2, my lord. Of the next note, my lord. Next note, my lord. Page 2, para 4, my lord. Top. So that is the rationale, my lord, of this. Therefore, my lord, some people may be 30 years old or very aged person, those have been appointed and continuing.
30 years is aged.
No, 30 years in service, my lord. Because there were previous, before 97 Act also, there are teachers and they were regularized in that 97 enactment. So therefore, to give a class of these are a class who never had a TET in their entire service career. At the end of the almost end or middle of their service career, this rule came into, the central rule came into force, which was also adopted by the state. And when looking at the difficulties of those situations, the amendment is made. That is, my lord, the only point which, and it is not that it is in repugnancy to the other act, because the other petitioners, they are appointed after 2012. So they are already there, and already that rule was there. The appointment is necessary. So that is a difference between these two set of employees, teachers before your lordships. And
yes.
Therefore, my lord, all these things I will not repeat, my lord, because my lord have already gone through this. I will only take you to page 6, my lord. Page 6 of second submissions, my lord. 14, 15, and 16. I will read, my lord. 14, 16. That in the aforesaid cutoff date is derived from the guideline issued by NCET. Actually, NCET gave a guideline how the TET will be held. So thereafter, we went in for a test. So that is why that date in the cutoff date, that 11 cutoff date, that 11/2/11 was derived. That was the date on which the NCET submitted directed the state government how to hold a TET test, and that is the date on which we have given that cutoff date, my lord. So my humble submission is, my lord, these teachers which are already there by virtue of another state act, and they are continuing in a cadre. Already there is a cadre, and they are continuing as per their seniority and other things. So they are suddenly they are asked to that if you do a TET test, then you are to suffer. That is to mitigate that situation, which is in my humble that it is not unjustified.
No.
this has been made, and there is no repugnancy, my lord. So 14, 15, and 16, I am reading, my lord, only. That the aforesaid cutoff date is derived from the guideline issued by NCTE under the agency under section 23(1) of the RTA Act, the conduct of TET and RTE Act for the first time, and basing upon the OTET, the first time was held on 4/6/2012, my lord. And therefore, date of said guideline by the NCET has an access to the cutoff date provided in the provision having access to the purpose to be achieved. And the RTA Act 2009 has advertisement has never any chance to appear in the TET and OTET test, since there is no guideline of the NCET on behalf, and therefore the exclusion at the entry level and thereafter cannot be declared as ultra-virus of the Constitution or repugnant to the Central Act. And teachers are a class, these teachers are a class by themselves being appointed before.
They may be class in themselves.
Yes, my lord.
And therefore they cannot be, their
No,
services,
that is exactly the, yes, ma'am.
their services may not be dispensed with on that ground. But when it says that for promotion, the NCTE guideline specifically says, the regulation specifically.
My lord, that we have already opened our card. My lord will decide those things, my lord, because it is already on the wisdom of the state government. They have done, because there are a lot of people there in the teaching.
No, we are trying to. In fact, we have also.
Yes.
According to you, when they lay down qualification, minimum qualification for promotion.
Yes. No, many of the got promotion in the old 97 Act also.
So they might have they cannot be disturbed.
Yes, my lord.
But now, when it came into force, the regulations came into force when?
The regulation came into force
2014. Amendment 2014.
Yes,
which prescribed TET to be a qualification.
Yes.
So in 2015,
my lord.
This was introduced that TET shall be a qualification.
My lord.
For promotion.
Obliged.
Then how can you ignore that?
My lord, is a transitional period, my lord. My lord, kindly see from one type of legislation to another legislation. That is why, my lord. Otherwise, my lord, if for any other person, government wants to relax, they can approach the state, central authority to take a view, and thereafter they can do it. But here is a transitional period, my lord, where both the acts are now merging with each other.
No, you could have framed the rules in 2011.
My lord, it was never, my lord, that timing, my lord, I am not disputing, my lord.
All right. Anything else?
This is the whole thing, my lord, only because that is only that why we made this act and this amendment, and it is only a transitional period and it is not a permanent nature. People retiring and they will be going, and therefore, my lord,
let us see the provision again. Where is that?
My lord, that provision is, I have quoted it.
My lord, that is Annexure 8, page 69.
I have taken it in. Page 4 of the second note, my lord, top.
No, not that, not Annexure 8. The provision which you are challenging.
My lord, we are challenging at Annexure 6. That is page 59. My lord, your lordship will find my compilation that I have put it.
No, just a minute.
I have put it.
Just a minute.
I have quoted it in my
1D
note, my lord. That is page 4. Page 4 of my second note, my lord. Page 4, top. My lord, I have quoted that, my lord, in my.
It is in the education manual also.
No, no, it has.
Page 529.
No, no. For your convenience, my lord, I have quoted that portion, my lord. Page 4, top paragraph, provided that the teachers appointed against the advertisements published prior to 11/2/11 are exempted from passing Odisha Teachers Eligibility Test 1 and Odisha Teacher Eligibility Test 2, my lord.
Page 66 of the brief.
No. Move it up.
First brief.
First reading. Yes, ma'am.
In the education manual that is there.
It is there also in the brief.
Page 529.
$529.
Yes. 529.
529, but the impugned portion is 530 of the book, my lord.
Rule 50.
That is the last proviso to rule 15(1)(d). That is top in 530 page. Provided that the teachers appointed against the advertisements published prior to 11/2/2011 are exempted from passing Odisha Teachers Eligibility Test 1 for Category 1 and Odisha Teachers Eligibility Test 2 for Category 2, which was the qualification as prescribed under 23rd August 2010 by the NCT notification. This was incorporated by way of amendment, while this Parliament has brought an amendment to the section 23 by giving post relaxation. Cut-off date is 31st March 2019. And this amendment came, my lord, prior to that, while that was governing the field. By sealing the date, no further they are shall have to acquire. Teacher in position shall have to acquire. This is the language of the amendment of section 23.
That my lord and friend has argued.
My lord. My lord.
Your compilation, you had.
Yes, my lord. Yes, sir. I have given the compilation. In the compilation, it is there, my lord. Page 7. Last page. Rule 15 starts from page 6. D1, then I and I proviso added to that. Proviso is 7 page.
No, where is the provision under the central rules? Which
Yes,
makes
my lord.
it compulsory.
Yes, my lord. My lord, may I, my lord, refresh your, my lord's.
No, just let us read. Don't have to refresh our memories. Just let us read that again.
My lord. My lord, section 23, that is page 2 of my compilation. 23 of RCFC Act.
Yes.
My lord, the proviso that was added by virtue of 24th of 2017 amendment to the RCFC Act with effect from 1/4/2015, provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualifications as laid down under subsection 1 of the section 23 shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the Right of Children for Free and Compulsory Education Amendment Act 2017. This is the act. But the RCFC rules also provide the how the relaxation the state government can seek, union territories and section state government can seek. That is next page. That rule came into force in 2010. Central rule, so also the Odisha RCFC rule, both bears the same provision in consonance with section 23. They have to move a proposal that is to be examined by the central government, and central government only can relax if satisfied. And they have relaxed not one, 2 occasions, and thereafter Parliament by way of amendment incorporated this proviso to section 23 by fixing a cut-off date. By this date they have to give in the last chance, as 4 years they have to acquire. (18), my lord. May I be permitted to read?
Sir, just a minute, just a minute. So what is the academic, qualification has been prescribed by the academic authority?
Yes, my lord, that is at annexure 2 to the brief, my lord, that I had given the copies, and that is also available in the brief. Annexure 2, that is NCT notification dated 23rd August 2010 at page 29. My lord, may kindly have glass, just the better copy I had handed over. Now I am also my copy, lords, may kindly have glass. That is available at page 29.
And what is the consequence? What is the consequence if a person appointed much before 2011 does not acquire the qualification of TET?
In terms of the 23, it is to be decided to what the section 23 says, my lord. They have given the what is the section 23 says, my lord. Section 23 says in the compilation that I have, my lord, entirety, my lord, I have quoted. May I read, my lord, the first para 1, 2, then proviso. My lord, it at page 2 of my compilation.
Yes, that we are seeing. What is the consequence?
My lord, they in subsection 2, they gave power that the central government can relax. My lord, may I read, my lord? Where a state does not have the adequate institution offering courses.
This is a situation.
My lord.
This is a circumstance.
My lord.
But let us think of a situation where a person appointed in 1997 has not passed TET despite the provisions. What will happen to him?
My lord, They,
What is the consequence?
consequence is, no, I am not saying that they will be thrown out because
According to you,
no, no,
it is
the
not that
rule
your
also,
submission
rule also
will be on
recognize them.
law.
My lord.
We just want to know
My lord.
that if someone does not acquire the qualification of TET, what is the consequence under the law?
Before the relaxation was given, there must have been some consequence for which this relaxation came. So what was that?
My lord, no penalty or no negative provisions was prescribed under the act. My lord.
But any, I mean,
Only relaxation was extended.
For what?
Time to, my lord,
why was it
to
extended?
acquire that qualification if not acquired.
If they don't acquire, what will they, I mean, what will they be deprived of?
Then certainly they cannot be substantially able to hold the post, my lord. After 2019, not prior to that.
So this is, according to you, the consequence is that they should have been removed.
No, from the post of promotional, if it will be read.
This is promotional post is your inference.
Hello?
This is your inference that promotional posts cannot be considered for promotion.
Yes, my lord.
Because for promotion, that is the minimum qualification.
Yes, my lord.
This is your inference. This is how you deduce on the basis
And on the basis of the regulation 2014.
On the basis of regulation, come to section 23(1).
My lord, 23(1).
Yes.
But any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as teacher.
This is over.
My lord.
Because this will not apply to person.
Yes, my lord. Yes, my lord. And two has looked after them. Two.
Yes, see, two.
Two, my lord. Where the state does not have the adequate institutions offering courses training in teacher education or teachers possessing minimum qualification as laid down under
different circumstance. Two deals with different situation. Whether you don't
proviso, first proviso, my lord. Two added with the two proviso. First proviso, which was existing with the act. Second proviso came in 2017. First proviso says, provided that a teacher who at the commencement of this act does not possess minimum qualification. This is important. This is existing from the day onwards. Teacher who at the commencement of this act does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 5 years. That was expired. Thereafter, but with the relaxation was extended even after 5 years. Thereafter, the parliament thought it appropriate in order to achieve that the goal of quality education of 8G, what the statutory obligation has been upon the central government sold to the state government. Parliament brought this amendment of 2017.
Yes.
They have to acquire within 5 years, my lord. While this was governing the field, they are given all opportunities and they did not acquire. However, the parliament in their that amendment act, second proviso was added. Provided further that every teacher appointed or in position.
Yes.
As on 31st 2015, who does not possess minimum qualification as laid down under subsection 1 shall acquire, my lord, such minimum qualification within a period of 4 years from the date of commencement of this Amendment Act 2017. Therefore, 4 years ended 31st March 2019. But at my humble submission, we have no grievance at all that the teachers, those who have acquired, many of them, my lord, they have acquired the qualifications. They have passed the TET. But what happened after even 2019, we the teachers, those who are petitioners, they entered into service with the TET qualification. And because of this exemption, the teachers, those who have not acquired such qualification, despite in between 12 to 2019, they are marching over and getting promotion despite.
That was up to 2021. They could pass TET up to 2021.
No, your lordship, gazette notification में kind of glance. I have quoted the portions.
Please read section 23.
Section Second provision, provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the Right of Children to Amendment Act 2017, which came into force, that is there in the Gazette, with effect from 1/4/2000. It is also in the Bare Act, my lord. It is reflected. That was given effect to, with effect from 1/4/2015. Had it been given effect to 2017, then 4 years means it is 2021. They consciously given effect to, with effect from 1/4/2015. Therefore, it ended 4 years by 31st March 2019. That the Gazette in my brief, my lord, it is available. In all the brief, it is available. That is, my lord.
So you are challenging because
Underqualified persons, they are marching over us.
They have had the
And Ballot-
qualification, but this is the new
Let us
qualification.
see this Amendment Act 2017.
My lord. 2017, in the notification, my lord, that I have 57 page, my lord, of my brief. The first brief, my lord. The entire Gazette I have enclosed, my lord. Ajan, your lordship, as 57.
Yes.
But
Yes. Just sit down. Yes, that's all.
Yes, that's.
My lord, we have filed an affidavit with all circulars and resolutions at flag E.
In which
That is, my lords, in 10430 of 2024.
Okay. Yes.
We have given, my lords, before I start, I would like to bring my lords kind notice. What is the prayer? What is the relief that prayer they have made? Though they have not, I have collected a brief from my learned friend.
No, whether the validity of the ISO is under challenge or not.
Yes, madam.
In every case, so address on that.
Yes.
Forget relief.
Yes, madam. Your lords, like first Tochi, these. My lords, these interveners, they were appointed pursuant to 1997 rules, my lord.
You might have been appointed in 1947. The question is that the law prescribed that you must have this qualification.
My lords, we do not
had to acquire that qualification.
We do not have any disqualification at all. That I would like to place it, my lord. Your lordship can have a look to the Rule 23. This is section 23. Qualification for appointment, terms and conditions of service of teachers. Your lordship have just gone through that.
Yes.
Any person possessing such minimum qualification as laid down by an academic committee authorized by the central government by notification shall be eligible for appointment as a teacher. My lords may pause it here. Question is, Your Lordship, in order to appreciate that, the academic authority, I have placed in my at page running page 77 of my note, affidavit. The academic authority, as per the provisions of section 23(1) of the OTT Act, Right to Children Act, is
Yes. Yes.
My Lord, sir, NCT has prescribed on 23rd August 2010 in exercise of the powers conferred subsection 1 of section 23 of the Right to Children of etc. My Lord, and
Where are reading?
my Lord, at page 77. Affidavit,
Yes.
my Lord, that I have given affidavit.
Yes, yes.
At page, that notification dated 23rd August 2010.
Yes, we have seen.
Yes, my Lord, that human resources, etc., my Lord, the Council of Teacher Education, NCTC, hereby lay down the following minimum qualifications for a person to be eligible for appointment as a teacher in class 1 to 8 in a school referred in clause N of section 2 of the Right to Children of Free and Compulsory Education 2009 with effect from the date of this notification. Your Lordship can have to do the qualification that was prescribed, minimum qualification for class I to B, that your Lordship will kindly get it. The senior, you also have already seen, we have placed it yesterday, senior, secondary, or etc. Senior secondary school. Then you also can have class from B to that is 6 to 8. The qualification that was required, my lord, is below. BA, BSc. Here, you also can see the qualification prescribed does not indicate that a person to have teacher's education training. Your Lordship can come to clause 4 of the same notification. This is important, my lord. Teachers appointed before the date of this notification. This notification date, my lords, have already seen that 23rd August 2010. Teachers appointed before the date of notification. The following categories of teachers appointed for class 1 to 8 prior to date of notification need not acquire the minimum qualification specified para 1 above. My lord, para 1 of the notification of at page 77.
Yes.
Therefore, my lord, those were appointed prior to the issuance of this notification dated 23rd August 2010, they are to acquire the qualification under which they were appointed. If they have appointed with their requisite qualification prescribed under the rule or statute that was prevailing, this 23rd August 2010 has protected them from all respect, clause 4, my lord. Teacher appointed before the date of notification, their minimum qualification, etc. Then a teacher appointed on or after 3rd September 2001, that is the date on which NCT determination, minimum qualification, etc. as amended, came into force in accordance with the regulation, provided that, nowhere it is written that TET or teacher's qualification is required. Whatever the qualification is prescribed here, and we are appointed prior to this, in order to... Your Lordship can have a look to clause 5 for a moment. Last, at page 79.
Yes.
Teacher appointed after the date of this notification in certain cases where an appropriate government or local authority or school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification. Such appointments may be made in accordance with the NCT determination of minimum qualification for recruitment teachers in school, Regulation 2001. Minus now can come to Regulation 2001. That is at page 68 of that note, affidavit, I'm sorry. At page 69, for the first rule, national council, etc. That is elementary, that's a prime. We all belong to the elementary cadre, my lord. There's a primary. We are also from primary schools. Senior certificate or intermediate or its equivalent and diploma or certificate in basic teachers training or of a duration of not less than 2 years or Bachelor of Elementary Education BEL, one senior secondary school certificate or intermediate or its equivalent and diploma or certificate or elementary teacher. Then my laws can have next upper primary school, middle school training or duration of not less than 2 years or bachelor elementary education or graduate with bachelor education. Then secondary and are not up, do not come to secondary and senior secondary school. Therefore, my lords, the regulation that National Council of Teachers Education, which was prescribed in the year 2001, did not prescribe any qualification to acquire TET. So this is being the, and my lords, National Council of Teachers Education is the authority to prescribe the educational qualification. And this has been accepted, adopted, my lords, in notification dated 23rd August 2010. Then, my lords, the question comes, the TET and how it is to be made applicable. Prior to that, my lords, I would like to say, in the 1997 rule prescribed by the state government, the qualification prescribed therein has been meted out by us. We are appointed, we have got the qualification that was prescribed as per the 1997 rule, statutory rule, framed under 309 of the Constitution.
All right. So your submission that because you had the qualification prior to coming into force of 2001 for appointment as a teacher, and because of the provision you were not required to acquire that TET qualification, you should not be removed from the post. But
yeah, I understand that.
But when the statute specifically prescribes that for promotion you should have that qualification, then how do you meet that?
My lord, for promotion there is no qualification prescribed.
There is no.
No, my lord. Only it required the number of years you have served in the institution. If, because my lord can appreciate, from the year 1997 till these rules came into persons who have been continuing and were confirmed and were regularly continuing. And now they want to put, my lord, the promotion they want to have, this promotion has nothing to do so far as, my lord, the ultra statute is concerned. If they don't have any specific qualification prescribed for promotion.
All right. So let us see whether there is any provision which requires TET for grant of promotion or not. That is a question.
Yeah. Your lordship can have a look to page 92. My lords, this is yes, my lords. This is what they want to take it off. My lords, I must make it clear. We have nothing. No qualification prescribed for us but for promotion. This is that is 12th November 2014 NCT's notification to their advantage. And that I have given my lesson page 92. Kindly have a look. Page 93.
Yes.
Rule 4A, small a. The qualification for recruitment of teachers, any recognized school, imparting pre-primary, etc., upper primary school, senior secondary or intermediate school, etc., college, imparting senior secondary school, etc., shall be given in the first and second schedules next to this resolution. Your Lordship can have a look to first schedule. This.
No, but before that, come to B.
My Lord, I will be able to.
4B.
4B. Yes, ma'am. 4A, qualification required. 4B, for promotion of teacher, the relevant minimum qualification as specified in the first and second schedule are applicable for consideration from one level to another level. My lords, in order to appreciate this, my lords, I would like to repeat, I will submit once again what 4A states. 4A states the qualification for recruitment teachers in any recognized school imparting pre-primary, primary, upper primary, secondary, etc., into senior secondary, etc., shall be given in the first and second schedule of schedules annexed to this regulation. That means, my lord, promotion as per this schedule, my lord.
There are two things. One, first is recruitment. First, A is recruitment.
Yes, ma'am.
And B is promotion.
Yes, ma'am.
All right. So A, you are not about. B, it says promotion of teachers. For promotion of teachers, relevant minimum qualification as prescribed in the first and second schedule are applicable.
Yes, ma'am.
For consideration from one level to the next level.
Yes, ma'am. Here, my lords, the schedules.
The exemption which has been given by the proviso
Yes,
may
ma'am.
apply to your continuance.
Yes, ma'am.
But not for the purpose of promotion. Therefore,
my lord, in order to appreciate me, I'll just disturb my lords for a minute.
why will you? We are not getting disturbed. We are very happy to hear you.
My lord, in order to appreciate me, can your lordship come to the schedule? It has a bearing to my submission, my lord.
Yes.
But in order that they must say that is according to the upper primary, etc., given the first and second schedule. 4A. 4A says first and second schedule, unless to this regulation. The schedule is annexed, my lords, at the top, in between. We are coming under clause 3, sir. Schedule primary for classes 1 to class 8.
Yes.
And the qualification they prescribed, my lords, have a look for a moment. The minimum qualification as laid down by National Council for Teachers Education by its notification dated 23rd August 2010 as amended from time to time issued in exercise of the power conferred under subsection 1 of section 24 of Right to Children and Free Compulsory Education Act. Here, my lords, may kindly watch. If somebody of us or we are interested to get a promotion as prescribed under sub-rule B, 4B, that means if we want to go from one schedule to another, one service to another schedule,
No.
I'm sorry, one label to another label.
Yes.
Label is the left side called minus subside. Label indicated in the left side of the schedule.
Left side of the schedule.
Heading label.
Yes.
That's the heading label, my lord.
Yeah.
This label indicate that we are in third level, clause 3, primary and upper primary. If we want to go to secondary, other level, my lord, because secondary has been prescribed as another level, and for that some other qualification has been prescribed. We are not going for any promotion level from one level to another level, my lord. We are continuing, we are the born cadre of elementary. We are continuing under the elementary. We will retire also as the elementary cadre. So this promotion, which is clause B, has got no bearing so far the elementary. Our rules are concerned for promotion. This is promotion if from level 3. My lord, can you see the next page? Second schedule. Same thing, but how can one be, if one will want to go for promotion from primary level 1, primary level to secondary high school level, then these qualifications are required. It has absolute. My lord, that I have just now read, minimum qualification prescribed on the primary is that the National Council of Teachers Education by notification dated 23rd August 2010. According to our qualification has already fixed that. Since we are continuing in the same level, we cannot go, even if we want, we cannot go.
No, second schedule is something else. Second schedule is for physical education.
Second schedule doesn't belong to us. That is for physical
We are
education.
confined to first schedule.
We might also want to confine to level first schedule.
So that is for both appointment as well as promotion.
Yes, ma'am. This notification relates to appointment and promotion. So far, the schedule, first schedule is concerned, my lord. If we do not go to the second schedule, other promotional avenue.
Level, not schedule. Schedule is different.
So that we are governed under the provisions of elementary cadre rules. Therefore, my lords, as primary school teachers, this has not brought to the kind notice of my lord. Only one part was read, part was not read. Therefore, my lords, in any manner, the rule, we are protected by the order of the NCT. We have got a required qualification. And in 2011, when the OTT came, your lordship can have a look at that, and is that document also. At page 82, 11th February 2011. I remember yesterday, my lord, what is the magic number, date? Why this 11th February 2021? 2001. 11, my lord. My lord, page 82. This is intimated to all concerned, all secretaries, commissioners, etc., in accordance with the provisions of section 1, subsection 1 of section 23 of the RTE Act, the National Council of Teachers Education NCT had vide notification dated 23rd August 2010 laid down the minimum qualification for a person to be eligible for appointment as a teacher in class 1 to class 8. It has been inter alia provided that one of such essential qualification for a person to be eligible for appointment as a teacher in any of the schools referred in the clause N of the section 2 of the RTE Act is that he or she should possess the teacher's eligibility test, TT, which will be conducted by the appropriate government in accordance with guideline issued by the NT. Here for the first time, my lords, they indicated, they directed that if anybody is going to he must have to have the OTT pass. This is on 11th of February 2011. That is why this has been deferred all through. And rightly, your lordship wanted to know yesterday. Why this magic number?
All right.
Since we are all appointees prior to that, we are all protected by the regulations and we are exempted. So no question of relaxation, sir. It appears there is a confusion between exemption and relaxation. We don't claim there is no question of relaxation. We are exempted by the authority, by the central government, by the state government. So in this background, the prayer made by them to declare ultravirus of the provisions as they prayed are not sustainable nor maintainable.
Yes, thank you.
I'm in the next intervention at flag D. Flag D. The entire argument, my lords, is premised on the fact and proceeds on the basis that certain minimum qualification, that is the my lords, acquiring the degree OTT or teachers training eligibility test to be taken, and that is mandatory for teachers who were in place, relying on the second proviso my learned friend was arguing. So therefore, in that context, my lords, if somebody has not taken, even though relaxation was granted, so he is, my lord, disqualified from getting further promotion, even though my learned friend concedes that, no, we are not against their continuance, but we are against their further promotion. My lords, what he, and my lords, the platform for advancing such an argument before your lordship is that, my lords, it's the virus that is being challenged. He is certain occupied field that the central government itself has laid down certain, my lords, qualifications that from 2009 onwards, effective from 2010, that's the date on which the notification was published, my lords, that from that date, state could not have granted any exemption. Now, my lords, the limited aspect that is to be examined here is whether the States Act is repugnant to the, my lords, 2010 guidelines, my lords, the guidelines of 2010 under the statutory powers section 23(1) or not, my lord. That is the limited question that is to be examined in my most humble and most respectful submission, my lords. Now, that 2010 guidelines itself says, my lords, the language itself is very clear. In exercise of powers conferred, this is incidentally, my lords, I'll take a pause here. Academic authority has not been defined anywhere under the Act. Section 23(1) says, just, my lords, for the sake of repetition, my lords, any person possessing such minimum qualifications as laid down by an academic authority authorized by the notification shall be eligible for appointment as a teacher. Now, academic authority by notification, my lords, there is some reference here in the rules. Rule 23 again, academic authority. The central government shall notify the academic authority for the purposes of section 29 within 1 month of the appointed date while laying down the curriculum and evaluation procedure. There are certain things that the academic authority...
For the purpose of section?
29. Section 29. That is, my lords, curriculum evaluation procedure. That chapter, that is chapter 5. Curriculum evaluation procedure. My lords, how that act is to be brought into... how that act is to be executed, my lords. The execution of the act. So this academic authority which was notified, my lords, that notification comes in for the first time on 23rd August 2010. Here, my lords, that, my lords, I have filed a small affidavit that, my lords, your lordship finds at flag D. My affidavit. Scan.
You mean what? Promotion from which post to which post?
My lord, your lordship compilation, your lordship.
No, forget compilation.
My lord.
Forget compilation.
My lord.
When you talk of promotion, you want to refer to what?
My lord.
Promotion from which post to which post?
My lord, promotion
referring to AICTE regulations, then 4A says about recruitment and 4B talks about promotion. 4B refers to level, and levels have been mentioned in the appendix. So, though the levels as mentioned in 4B shall not be referable to the recruitment rules, rather levels under the regulation. Are we clear?
That there is an answer. What they presented, we will give.
No. That is, they have not presented. This is what we have understood. That when it refers to level, then it refers to level as in Appendix 1 of the regulations, 2010 or something.
2014.
So 2014. So this level does not refer to level of the recruitment rules. All right. If promotion is to be granted from, say, elementary level to next level is secondary level, then that is a level. And in that case, that TET is required.
Eligibility test, it has clearly carved out an exemption, my lords. Rule 4 carves out an exemption, while Rule 1, minimum qualification under 1, that your lordship finds in 79 of that affidavit filed by my learned senior Mr. Rath, 79, minimum qualification, classes 1 to 5, senior secondary or its equivalent.
Yes.
Minimum qualification, classes 1 to 5, senior secondary or its equivalent with at least 50% marks and +2 diploma in elementary education by whatever name known, or senior secondary or its equivalent with at least 45% mark and 2-year diploma in elementary education by whatever name it's known in accordance with NCET recognition norms 2012, senior secondary or its equivalent with at least 50% and 4-year bachelor's of elementary education, and pass in the teacher's ability test. Now, to be conducted by the appropriate government in accordance with the guidelines framed by the NCET. We are hit here. Now, this is what he is saying, that we should have acquired this one. Now, my lords, we are direct recruits. In the 1997 rules, we have all the other qualifications required. We are direct recruits. We have come in through open market merits competition. And we have all the other requirements as necessary under the rules. This rule comes in 2009, implemented in 2010. By virtue of this implementation, my lords, while exercising the powers, the government was very conscious that there would be other equities will be disturbed. Vested right of promotion, which is linked to the the factum of my recruitment through a regular process, I would have an automatic right to promotion basing on my seniority. So that would be disturbed if suddenly a new element is introduced that is in the form of a teacher's test. So therefore, they gave an exemption for teachers for page 79, your lordship, that's at page 79. Teacher appointed before the date of this notification, the following categories of teachers appointed for classes 1 to 8 prior to date of this notification need not acquire the minimum qualifications prescribed in paragraph. A teacher B, a teacher appointed on or after the 3rd September 2001, that is the date on which the NCTE, minimum qualification regulations 2001, came into force in accordance with these regulations. And then, my lords, C, a teacher appointed before 3rd September 2001 in accordance with the prevalent recruitment rules. So whoever was already appointed in accordance with the prevalent rules which were there, which would mean us, the category of lecturer to whom we belong, we were protected and saved from by that notification. It was special, my lords. And then, my lords, your lordship, Clause 5, the advertisement. It teacher appointed after the date of this notification in certain cases where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification. Such appointments may be made in accordance with city qualifications. Where advertisements have been initiated for process of recruitment, those also were brought in under the four corners of this notification. Then the next one, 2011, page 80 of that. Page 80, there they gave 1 year more, 2000. This was on 29 July 2011. 1 extra year, that is at page 81, para 5. For para 5 of the principal notification, the following shall be substituted, namely 5A. Teacher appointed after the date of this notification in certain cases where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers. Between 10 and 11, those advertisements, they were also brought in the protected. That you are also covered by this. Then and then page the next page, that is
By
the
what? The exemption or the NCT?
exemption. Now, coming to my learned friend, laid huge emphasis on this, that notification dated 12th November 2014, page 92. Page 92 of the affidavit by learned senior, here. Qualifications for recruitment. That's at page 93. 93, the qualifications for recruitment of teachers in any recognized school imparting primary, upper primary, secondary, senior secondary or intermediate schools or colleges imparting senior secondary education shall be given in the first and second annex to these regulations. B. For promotion of teachers, the relevant minimum qualifications as prescribed, specified in the first part, and the second schedule, first and the second schedule are applicable for consideration from one level to the next level. So this is, as my learned senior was placing with great emphasis, Mr. Rath, that from one level to the other level, that this within within primary school, then this level, your lordship, first schedule is that in the left hand left-hand column.
Yes.
Primary and upper primary. We are all primary and upper primary from classes 1 to class 8. Minimum qualifications as laid down by the National Council for Teacher Education via its notification dated 2010, as amended from time to time,
yes,
issued in exercise of power. So now this 2010 would apply, along with the entire notification would apply, along with the exemption granted, obviously, my lords. So that saves our promotion. Instead of, my lords, affecting it like or making us disqualified, rather it saves, my lord. That is the submission that. And so therefore, my lord, the state rules cannot be challenged on the ground because the exemption, they have just followed what the Central Act has done. So therefore, there is no repugnancy, my lords. Rather, we have the state rule is completely in sync with the national, my lord, the Central Act. So the entire argument would be, my lords, would
yes,
fall.
Yes, after 6 years.
And the challenge has been made after 6 years.
Challenge
That cannot should be considered. So therefore, there's no repugnances, but my most humble and respectful submission.
Compilation.
My lord, I have prepared a compilation. Although I have not filed any intervention application, since I am supporting the interveners, therefore I am addressing it. My lord, my learned senior friend, both the senior friends have argued before your lordships.
Covered.
I am starting my argument with one judgment of Allahabad High Court. But this point is no longer res integra. It has already been decided by Allahabad High Court that those who have under the exempted clause, my lord, their right to appointment, right to promotion, everything is protected. My lord, may kindly see. My lord, in my compilation, I have given that. My lord, may kindly come.
This
Page 49, towards last. It's a recent judgment, neutral citation number 2024, Allahabad High Court, 49330. My lord, may kindly come to page 40, paragraph 3. Page 50. Here, my lord, the NCT also has filed an affidavit and clarified the matter. Parties are in agreement. My lord, got it?
Yes.
Paragraph 3. Parties are in agreement that on the basis of affidavit of state as well as Council for Teacher Education, controversy could be diluted and clarified if this court passes an appropriate order in terms of notification and its implementation. Before passing the direction, it would be relevant to quote relevant paragraphs of affidavit filed by NCT. That NCT, in exercise of power under subsection 1 of section 23 of the RT Act, by notification dated 23/8/2010 and 29/7/2011, has prescribed minimum qualification for appointment as teacher for classes 1 to 8. That by notifications passing the teacher eligibility test conducted by the appropriate government in accordance with the guidelines framed by the NCT is one of the criteria of becoming teachers for classes 1 to 8.
Yes, we have seen.
Towards last, your lordship may kindly see paragraph 5.
We have seen, Mr.
In these circumstances, it is clarified, my lord, appointments before notification dated 23/8/2010 does not mandatorily require to pass TT and their promotion whether they have passed TT or not.
All right.
And so far as appointees subsequent to 23/8/2010 are concerned, their promotion shall be considered if they have passed TT primary or TT upper as the case may be.
So this order has been passed on basis of the affidavit given
By the
Does not
NCT. Here, my
decide-
lord, NCT has been
not
made a
decided
party.
anything, but just
Yes,
repeated
my lord,
the.
NCT has been made a party in this case. So this is the affidavit given by the NCT. Then my point is, because much has been said about 2017 amendment, my learned senior friend or my friend has not addressed on that. Your lordship may kindly, for a moment, your lordship may kindly see the 2017 amendment, which was given retrospective effect from 2015. In my compilation, I have given. My lord, may kindly come to page 33.
Yes.
My lord, this amendment by the Parliament was made on 10th August 2017. My lord, the proviso was added to section 23, subsection 2, after in the Right of Children to Free and Compulsory Education Act 2009 in section 23 in subsection 2. After the proviso, the following proviso shall be inserted, namely, provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the Right of Children to Free and Compulsory Education Amendment Act 2017. Well, at pausing here for a moment, my lord, so far as the Amendment Act of 2017, which was given retrospective effect from 2015, that is meant for teachers who were appointed after 23/8/2010, not prior to that, because prior to that they are exempted. Since they could not acquire the training qualification within a period of 5 years, as per relaxation given to them under section 23(2) of the Act, therefore, my lord, this provision came. And I have given the bills also. My lord, my legislative note, page 35. Your Lordship may kindly come to page 36. That is the statement. My Lord.
Yes.
Highlights of the bill. The right of children to free and compulsory education RT Act 2009 became effective with effect from 1st April 2010. It envisages free and compulsory elementary education to every child in the age group of 6 to 14 years. The proviso to section 23(2) of the Act specifies that all teachers at elementary level who at the commencement of this Act did not possess the minimum qualification as laid down in subsection 1 of the said section under the RT Act need to acquire these qualifications within a period of 5 years from the date of commencement of the Act, that is 31st March 2015. After completion of the said period, the state governments have not been able to continue the training process for in-service untrained teachers. Hence, the state governments have requested for extension of the period for training untrained teachers so as to enable them to initiate and complete the said training process. Then your Lordship may kindly, as reported by the several state government, out of total 66.41 lakh teachers at the elementary level, over 11 lakh are still untrained. Of this, about 5.21 lakh belong to government and aided schools, and about 6 lakhs to private schools. State-wise number of untrained teachers is given in Annexure 2. In order to ensure that all teachers in position as on 31st March 2015 acquire the minimum qualification prescribed by the academic authority.
But you have missed one point which is in your favor.
Yes.
Two highlights of the bill.
Highlights of the bill. Yes, my lord.
The right of
children which came into force with effect from 1st April 2010.
It envisages
Free and compulsory education to every child in the age group of 6 to 14 years. The proviso to section 23(2) of the Act specifies that all teachers at elementary level who at the commencement of the Act did not possess the minimum qualification.
did not possess the minimum qualification as laid down in subsection 1
of said section under RT Act.
Now come to the footnote.
Yes. Any person possessing such minimum qualification as laid down by the academic authority authorized by the central government by notification shall be eligible for appointment
So
as a
this
teacher.
was for those who were not qualified.
Absolutely correct. I am grateful to your lordships. So my submission before your lordships is,
yes.
So they form a different category because all these teachers were appointed prior to 23/8/2010 in elementary cadre, and most of the teachers have got promotion to many levels. And level, my lord, my learned senior has already addressed about that. This is my argument. And
It is annexed bill.
No, one is the bill, thereafter the amendment.
Yes, yes.
Here.
My lord, at
Page-
page 33. Page 33 of my compilation.
No, but how do we rely on this
My lord,
amendment bill,
amendment bill from the NET,
legislative note?
legislative note.
How could you get it?
Online it is available.
Is available?
Yes.
Just like that on website of some.
Yes.
We have downloaded it yesterday.
No, from the
Someone
website.
I
Ministry
do
of-
not bring the hotspot is
son.
very crucial. This document is crucial. You will have to bring this on record.
Yes.
We have affidavit, my lord.
With the lordship's permission, legislative note.
No, that is available in different websites, but
We cannot see the website.
I will
We
file an
cannot decide
affidavit.
cases on website on the basis of information available. Yes.
Let them file the
Yes.
affidavit. Will be opportunity to reply. Let them file the affidavit, make it a part of the record, and also we will be given opportunity to go through it. My lord.
All right.
The bill and all.
This is matters on. Who will file affidavit? You will file?
Yes.
A submission has been advanced on behalf of the interveners that the requirement to acquire the qualification as stipulated under section 23 bracketed under second proviso to section 23 bracketed 2 of the right of children to free and compulsory education act 2009 applies to such persons only who did not have the minimum qualification as laid down by the academic authority authorized by the central government by notification under section 23 bracketed 1 thereof. Yes. So stop. They have relied on the notification of 2014 notification. Where is that? They have 2014.
2014.
Of the
14 at phase 20. November 2014. Of my
Page-
compilation.
Page
25.
35.
25 of my compilation.
Notification dated 12 November 2014.
They have relied on a notification issued by a gazette notification issued by the NCTE dated 12/1
11.
12/11/2014. Which clause?
My lord, that is 4A and 4. At page 30. So also the first schedule level.
No, where is that provision which requires that, which provides that it shall not apply to the persons appointed?
That is at 10, 2010.
2010.
2010. That is
Page one.
page five of my compilation. Para 4. Para 4, page 7.
Page 7. A notification dated 23/8/2010 issued by the NCTE
Para 4.
Para 4A of which contemplates that a teacher that Para 4 of which contemplates that certain category of teachers appointed for classes 1 to 8 prior to the date of the notification need not acquire the minimum qualification specified in para 1 of the said notification. First off, it is their case that the said notification dated 23/8/2010 is the minimum qualification, lays down the minimum qualification as required under section 23 bracketed 1 of Act RC FCE Act 2009. This is your submission. This notification is in light of 23(1).
Yes.
Our attention has been drawn to the highlights of right of children to free and compulsory education bracketed amendment bill 2017 leading to enactment of right of children to free and compulsory education 2000 Amendment Act 2017 to submit that a person possessing minimum to submit that the said amendment shall not require a person to acquire TET qualification who possessed the minimum qualification as laid down by the academic authority, that is NCTE, in its notification dated 23/8/2010. So stop. And senior counsel seeks adjournment to bring the said and senior counsel appearing on behalf of the petitioner has submitted that for
Intervention.
intervenor has submitted that for just interpretation of section 23, interpretation of the second proviso to section 23 bracketed 2 of the Act, this court may take aid of the highlights of the Amendment Bill 2017, which is part of the legislative note. So stop. As requested, these matters on 2 weeks. It is expected that the affidavit shall be filed within 1 week from today, after serving copy upon learned counsel for the petitioners. 2 p.m. 2 p.m.
Test admission item number 20.
May I please? The petitioner is a partnership firm who has participated in a tender in pursuance to the advertisement by Annexure 2. At the time of evaluation of the technical bid has been rejected on the ground that he has been blacklisted. The runner have looked to page 30, man. Page 30.
Page 20.
Page 33.
20.
33. My serial number at 8. Mr.
Yes.
Care Security and Allied Service. My technical bid has been rejected.
Which page? Which page?
Page 30.
30.
Yes.
Yes.
And my serial number is 8. Mr. Care Security and Allied Service. And my technical bid has been rejected on the ground the agency have been blacklisted by the CDM and PHO cum District Mission Director NHM Kandhamal since 9/2/2021. Well, though that blacklisting has been withdrawn on 19/7/2000 of the collectors, and thereafter the stigma made therein has been lifted by this Honorable Court by order dated 24/7. That after knowing that, I have intimated that that has been lifted by my annexure 5 lordships, along with the order passed by this Honorable Court. That is page 34 and 35.
Yes.
But in
So you
pursuance,
could have brought to their notice.
well, I have brought to the notice on 1st of August. They have rejected my single bid on 29/7. After knowing that, I have intimated on 1st of August, along with the order of this Honorable Court.
So they will take a decision.
Well, they have not taken decision. Not, I have specifically stated that I have intimated by 2nd of August, but they have did not intimate anything. For that purpose, I have approved this honor.
Yes, madam.
I'll seek instructions. Yeah.
Seek instructions. 2 weeks. 2 weeks time is allowed for so issue notice, also notice. 2 weeks time is allowed for the state to file counter affidavit. Let's this matter on 2 weeks, first 5 cases.
Item 21.
This case is there. And this case is there not to take a final decision.
What is the stage?
They have only filed the technical finance. On the present status not been known to me. They have openly technical bid, and suddenly they have finance bill has been opened, but they have not taken a final.
The petitioner's technical bid has been rejected on the ground that who is the petitioner? That it was blacklisted by an order dated 10/2/2021.
9/2/2021.
9/2/2021. Mr. Upland, counsel for the petitioner has made twofold submissions. Has submitted that the said order of blacklisting was withdrawn by the authority which had issued the order on 10/7/2000. When?
19/7/2000.
19/7/2021. 21. Stop. He has also drawn our attention to an order of this court dated
2024.
24/7/2024, whereby this court had disposed of petitioner's writ petition, that is WPC number 40185 of 2021, that no observation made in the order of blacklisting dated 19/7/2021 shall be treated to be a stigma against the petitioner for any tender in which he may participate after 19/7/2021. Full stop. Next. IA number 10102 of 2024. This application has been filed seeking interim order directing the opposite parties not to take a final decision pursuant to the tender call notice in question, that is 10/7/2024. So, taking into account the above noted facts, we prima facie find substance in the submission so advanced on behalf of the petitioner. Stop. Accordingly, it is directed that the opposite parties shall not take a final decision based on the said tender call, the concerned tender call notice dated 10/7/2024 till the next date.
Oblex.
Yes.
Item number 21.
My lord. Here the petition is against the or notification under annexure 4 is 32. Challenging this order is the legality and validity of this notification, which is in violation of provisions of CRPC, especially which is against section 139 of CRPC, 167 and other of. Yeah. As far as this notification, I would have lots of kind attentions.
So which you are referring to, which provision?
Beg your pardon? The notification. Notification under annexure 4, page 32. Page 32.
Yeah.
May I read it?
Yes.
The state government, with concurrence of the High Court of Orissa, do hereby designate the existing 4 number of special courts established under the Orissa Protection of Interest of Depositors in Financial Establishment Act of Orissa, Act 21 of 2013, as special court by and dispose of cases initiated by economic offense wing for the areas specified in column 2 of schedule given
Who
below.
are you?
Beg your pardon?
Who are you?
My lord, I am an accused in this petition, and the petitioner is an accused. I was apprehended for the alleged offences of 420, 467, 468, 471. All these offences are triable by magistrate. After I being apprehended, I was forwarded to this court of OPID Act, which is a special court, which is a court of sessions. After that, subsequent it was submitted. When after submission of charge sheet, I filed a petition before the court saying that all these offences which I have been charged with is triable by magistrate. Hence, this court lacks jurisdiction to try all these cases. In that order, then that rejection or that order was rejected, and in that order, the law and lower court says that this by this notification of this which I have challenged here, they have designated this court as a special court. Question comes, my lord. Being a sessions court, basing on a notification, can a jurisdiction be created? As a sessions court, it is hit by section 193 of CRPC. Okay, when this when the court doesn't have
Let us see the notification.
Bigger pardon?
Let us see the notification.
My lord. Page 32.
Where is this act?
Bigger pardon?
Act of 2021.
OPID Act. Sorry. OPID Act. My lord, I have reproduced the entire OPID Act also in this
Let
petition.
us see. We will see.
My lord.
Yeah.
Section OPID Act 9. Again, there was well, OPID Act Section 2C. Designated court means the designated courts constituted under Section 8.
Yes, there is no merit in your case.
Beg your pardon, madam?
There is no merit in your case.
Madam, let me submit. Just I will
come to subsection 1 of section.
Section 1 of section.
Yes.
Subsection 1 of section
8.
8.
Yes.
Okay, I understand. My lord, for the purpose of this act, the government may, with concurrence of the Chief Justice of Orissa High Court, by notification, constitute one or more designated courts of such areas in such cases may be specified in the notification, which shall be presided by an officer belonging to the Odisha Superior Judicial Services. I accept it. That is my submission, my lord.
Yeah.
What I say is, this is a special court being presided by a senior judge, that is ADJ.
Yeah.
Now it's a court of sessions. My mission is all the offences which I am charged with are triable by magistrate.
He will act as a magistrate.
I'm coming. Minute, just 1 minute. I'll take you 1 minute. All the offences are triable by magistrate. When this is triable by magistrate, now question come, can a sessions court take cognizance of the offence?
Yes. Court can take cognizance.
Court can?
Yes, take cognizance. Court can take cognizance.
No, it is barred by section 193 of CRPC.
193 is a special act.
Oh, no,
193 is general.
My lord, in this
193, Mr. Counsel, is general.
CRPC.
This is a special provision. A special provision will prevail over.
I accept it. But as far as this act is concerned, my lord,
Yes.
this OPID Act, when it comes into force, once sections of OPID Act is implicated, then only this comes into action. And that court, the jurisdiction of that court arises.
All right.
But in this instant case, I don't have any offense under OPID Act.
All right, let us see what are the offences.
FIR is on 17.
What are the offenses under the act?
There's only one offense, my lord, that is
Where is
offense
that?
6. 6. Offense is 6.
Fine.
Six OPIDI.
So there is no allegation against you of return
No,
of
my lord, no.
deposits?
No, that is the reason why I come to this.
Return of deposits or defaults?
No, no. If anything of that sort would have been there, certainly they would have implicated me under section 6 of OPID. It is not a case of that.
Whether there is any allegation of default
Default payment
return of the deposit or default of
No,
payment?
no, my lord, no.
What is the allegation?
No. The allegation is he has taken money to give job to some persons. To n numbers of people, he has taken money, but he has not provided that. And he has cheated them also. And at the same time, he has forged some documents of state government.
You can file an application for quashing. Not this.
My lord?
The notification cannot be said to be bad.
I had on that also, on that, this
Mr.
court has...
Counsel, you can challenge the order which has been passed, but not the notification. If you can't understand this, then it's very difficult. The order which has been passed in your case, you can challenge that in appropriate proceeding. But there is nothing wrong with the notification. The petitioner in the present civil writ application has put to challenge notification dated 4/3/2023 issued which department? By the Home Department, Government of Odisha, whereby with the concurrence of the High Court of Orissa, 4 special courts have been established under the Odisha Protection of Interest of Depositors, bracketed in Financial Establishments, Act 2011 and Odisha Act 21 of 2013 as a special courts to try and dispose of cases initiated by Economic Offences Wing, bracketed EWO, EOW for the areas specified in column 2 of the schedule given in the said notification. Next, learned counsel appearing on behalf of the petitioner has submitted that he has been made accused for the offences punishable under sections
420, 467, 468, 471
of the Indian Penal Code, and therefore no provision of the OPID Act applies in his case. First off, his case has, however, been transferred. Your case has been transferred to that court.
My lord.
Transferred to the OPID court, Bhubaneswar. Where?
Cuttack.
Cuttack.
No, my lord.
Cuttack. First off, he submits that all the cases instituted against him are told by magistrate, and the special court under the OPID is Court of Additional Session Judge.
My lord.
First off, next. Section 6. Section
6 of OPID Act.
Yeah. Section 8 of the OPID Act confers upon the government to power to designate Odisha Superior Judicial Service as the designated court within the meaning of section 2 bracketed C of the said act. Stop. We do not find any illegality in the notification because the petitioner's case has been referred to the OPID court. Stop this application.
Is to be borne by the mining holder, my lord, 9B, my lord. And this has been, my lord, in a case of, my lord, 2 judgment and 9 judges bells also taken into control under section 9B that the mining holder is supposed to pay the, my lord, district mineral fund, my lord, because the extraction of mining, the object is
Who are you?
I am a contractor, my lord. They have raised a contractor. I am a contractor, completed the project, royalty recovered from amount, final bill paid, no dues certificate issued. Now they say you, as per the circular notification, you have to pay the district mineral fund on the royalty paid by you.
So district mineral fund, according to you, is to be paid by them.
Yes, my lord, that is the law, my lord, the section provides. Your lordship, MMDR Act, your lordship.
Section
9B, your lordship. Lordship, 9B, District Mineral Foundation, lordship. In any district affected by the mining related operations, the state government shall by notification establish a trust as a non-profit body to call a district mineral foundation. Lord, the 9B5, your lordships. The holder of a mining lease or a prospecting license, mining lease granted or after the date of commencement.
Where are we reading?
Lord, 9B5, sorry.
5, yes.
Your lords. Lord, 9B subsection 5, your lords.
Yes.
The holder of a mining lease or a prospective license, mining lease granted.
Or a prospective
license, my lord. Or a prospective license. Mining lease, then your lord.
Composite.
No.
Your
You are
lordships.
reading a different book.
Your lordships. Your
It
lordship,
was
9.
amended in 2021. Prospecting license, mining lease
Or a composite.
has been substituted by composite license.
Composite license.
That, my lord, I've said 2019.
Yeah.
Composite license. Sorry, my lord. 2019.
So you are holder of a license.
No, I am not a holder of that. I am studying the notification, my lord. That is, lordship, that. Sorry, my lord, this 2019.
The mining
I am a contractor. I have a under railway, my lord, for a doubling of road work, construction, civil construction work. And the notification, if your lordship permit, my lord, the 9B. Salve district 9B, the holder of mining. I'm a paper royalty, my lord. That, my lord, my lord, back to that, I have researched about whether the district mineral foundation will apply to us. The notification, whole notification, I have got, my lord, interstate notifications as well as the, my lord, central notification has been quoted in the, my lord, Federation of Mineral cases, and they also.
So you don't have any legal
No, my lord. I have
you have just violated the provisions of the Act.
Because I am statutorily exempted to pay the district mineral fund.
File your affidavit, we will see.
Your lordship, notice will go to the Union of India and Railways, your lordship.
All right.
The act.
We are appearing for
No,
1,
more, my lord.
1, 2, and 5, 6, 7.
All right. This is notice on behalf of opposite party number 1, 2, 5, 6, and 7.
And I take notice on behalf of 3 and 4, your lordship.
Notice is accepted on behalf of 3 and 4
Yes, your lordship.
by so and so. Stop.
My lord, they have no that they will, since my final bid has been paid, they are saying to other work mill they recover. That is annexure 4, where the contractor not to take any coercive action.
That's what I will take instruction, my lord, thereafter, Lordship.
The observation, because already your lordship kindly see the one annexure page subject to your lordship permission. Your lordship. Page your lordship kindly have page. One page your lordship.
Yeah.
Subject to for 358 your lordship. 358 your lordship.
Yes.
Your lordship page 35 your lordship. Your lordship last two columns your lordship in top 1, 2, 3, 4th line royalty amount recovered from. Your lordship kindly see the recovered that 2 crores 49 lakhs already recovered, Miller. Now your lordship, the second paragraph. DMF contribution to be recovered, Miller.
Your page?
Page 358, your lordship.
Yeah, there on 358.
Your lordship, kindly the box, Miller, royalty already paid, Miller. The top, your lordship, serial number 1, 2, 3, 4th line, your lordship. In top heading box, your lordship.
Yeah.
The column, Miller, the royalty amount recovered. Miller, they have recovered, Miller. We are not problem. Miller, this next term, your lordship. They supposed to be, they say that this is to be, the DMF continue to be recovered, which is to be done 2020.
So what for did you pay royalty? If you did not do any mining work,
yes.
Then what for did you pay
For the account consuming the royalty, consuming the mineral, Miller. The boulder, chips, minor mineral, that consuming, that Miller, the excluded for the, only the excluded for payment of district mineral fund. Your lordship, the rules, Miller. Your lordship, page 365, the state rules, Miller, notifications. Bloody start frame, your lordship, on the basis which letter they have, start frame page 360, annexure 5. That letter on the state government letter, they have input, page 360, your lordship. Your lordship, this is the district mineral foundation rules, your lordship. The liability I am saying, your lordship, kindly have page 365, lords. Funds of the trust and 6, 7 and 9, your lordship.
365.
365, your lordship, sorry.
Yes.
365 and 36, Miller, 7 and 9, Miller. The funds of the trust shall be compromised payment to the trust made by the lessee of major mineral lease at the rate by the to be specified the central government, and payment to the trust made by the lessee of minor mineral lessees of minor mineral lease the rate specified in these rules, Miller. 7B, your lordship. Only lessee, your lordship. The judgment is Miller statutorily exempted. Miller, your lordship can have the I have a Miller that I have query about the liability of 9 judge bench also, Miller, regarding taxation. They made a paragraph 9B only the prospecting license holder, your lordship. Paragraph 69. Before that is a big judgment. I have also made 69, 70. Paragraph 69, your lordship. And here is a case, no due certificate has been issued. That I have no against claim, I have not to bid. Yes. Yes, exactly. A contractor, Miller. Your lordship can
see the mines belong to whom?
Miller, the state, your lordship.
The state.
Your lordship.
It did not belong to railway.
Did not belong to railway.
You were working as the contractor of railway.
Your lordships.
Now you extracted mineral.
No, I have not extracted Miller. Extraction is to be bound by the mining holder, lease mining holder. I am only to use that. Miller, the boulder, Miller, doubling of railway work, Miller. I am a contractor.
Not only that, it is clear. It is clear from 358 itself.
Your lordship. No, I have no excavation. I have no license. I am only to use. But your lordships kindly 358, your lordship.
What is the work?
Miller, what is
Jagdalpur Koraput doubling project?
Again,
execution of earthwork.
Earthwork, construction of minor bridges, Miller. Which quantum? Even if that demand,
please read it.
So, extremely sorry. District Mineral Foundation, Jagdalpur Koraput doubling project, execution of earthwork, construction of minor bridges, protection works, including other alleged works and supply of machine, crossed hardstone track, ballast between the Chatriput, Maliguda
Supply of
stations.
machine crushed hard stone. Who did it?
Milord, supply of machine crossed hardstone, Milord.
Railway has got a lease. You have been asked to do that work, you have excavated and used. Railway has not got a lease for taking out the boulder.
And how could you do it?
Milord, I purchased, I am only liable for royalty, Milord. I am that for which they have recovered.
Under which provision?
Milord, 9B, your lordship, that I am, your lordship, that. Lord, I may be permitted to be a lordship subject matter one subject Milord one your lordship notifications. Regarding district mineral foundation, only all this.
Get district mineral fund, Mr. Counsel. Did you supply machine crushed hard stone?
As per the contract, Milord, is the contract, Milord.
From where did you
Have
get it?
taken query lease, your lordship, on my.
That has not been sent in impung
query
order.
lease.
That is not in the impung order I have queried. They have said you have
Not then let the affidavit come.
my IA may be including IA may be notice, Milord.
Oh, IA is there. Let them file it.
Oblige.
Your affidavit is also necessary.
4 weeks.
Yes, yes.
Item 23.
May I please, Milord? Here is Milord's tender relating to the construction of the road work floated by the opposite party number 2, Milords. And it is a matter relating to the tender for construction of the road work floated by the opposite party number 2, Milords. As per the schedule, they have opened the financial bid on 14th November 2023. And I have been informed that Annexer 5203, page 203, Milords.
Yes.
Let's kindly have a glance. It is informed you that your bid number such and such has been opened and updated summary by the
Duly
considered constituted committee. Your bid has been admitted by the committee and further informations are to be added. That is the Milords. My bid has been opened, Milords, in 2014. After 2023, 14 November 2023, Milords. Then your lordship, see Annexer 6205.
Yes.
Your lordship, it is informed that due to administrative reasons, the above tender has been revoked from the technical evaluation to the technical bid opening. As absolute for inconvenience, thank you for interest of the shown participation. And same bid has been opened, Milords, next page 206, Milords. Same bid, Milords. Wherein Milords again opened after 10 months of the Milords opening of first technical bid. Same bid again opened, Milords, in the 1st August 2024. Your lordship, see that page 206.
So this is also to you. This communication is also
Yes, Milords. Milords, in the first opening of technical bid, opposite party number 3 is disqualified. Milords, I have been told by the office, but that bid has not been uploaded in the, though tender condition is that you have to upload it, that not uploaded, this bid is informed me. But opposite party number 3 is not completed similar nature of work, therefore disqualified. In 1st August, when technical bid was open, that they make eligible to the opposite party number 3 in technical qualification. Thereafter open the finance bid, Milords. In finance bid, Milords, I am less than 11% of the estimated cost, and opposite party number 3 quoted less than 4%. Because opposite party number 3 is scheduled caste community, and as per the circular, they are going to work, issue work order in favor of the opposite party through, though I am L1. That is circular, 10% will be added in the Milords. In first opening of tender, Milords, they are disqualified, not completed, not eligible, Milords, disqualified, Milords. Your lordship, see that
No, if we have understood your submission correctly.
Yes, my lord.
There was one tender notice
Yes,
against which you had applied and opposite party number 3 had also applied.
applied.
Your technical bid was found to be responsive. He was found to be disqualified.
Yes, my lord.
All right. Later, your financial bid was also opened.
No, thereafter, my lords, again, that same bid has been opened in after 10 months, my lords. Now, first opened in 14 November and that has been revoked in 1st August. Thereafter, same bid again opened.
Thereafter, it was revoked and same opened.
Same,
How can this happen?
same has been opened.
Instructions, Your Lordship, since he belongs to the SC category, I have
No,
to
but
take
once he
instruction as
was
to why he
disqualified-
was.
Once he was disqualified and you decided to revoke the
Your
notice, then how could you proceed on the basis of same notice?
He was disqualified, Your Lordship, that I have to.
Not uploaded, I have
whether
taken a
he
plea.
was
Dix Miller's
actually
officers told me that disqualified.
Office,
Yes.
who told you in the office?
Miller's office, I have taken a pleadings that Miller's let them
That is not the question. The question is on 1st of August,
Yes, Your
he was
Lordship,
informed
that it was
that-
revoked.
that it was revoked.
Yes.
And on 2nd of August,
First they have scrutinized the technical.
Same day, same day.
Same day,
Same day.
same day.
same day.
Same day.
Issue notice, accept notice. Let counter affidavit be filed. In the meanwhile,
Item 24.
My IA is there, Miller's. They are going to, Miller going to issue work order in favor of opinion number 3.
any action taken based on the tender notice in question shall be subject to final adjudication of this case.
Item number 24.
One time will allowed, madam.
Why?
The counsel of the petitioner, mother of the petitioner.
Item 25.
25 will also may be permitted to withdraw to file a better writ application.
Why better?
It's per Lord's liberty may be given to file a better writ application, my lords.
Why? What is wrong with this?
My lords, I have not annexed the last query permit of the present petition. So that needs to be annexed. I'll file a better writ application, my lords. I pray for liberty. Filing a memo, my lords.
Counsel for the petitioner seeks permission to withdraw this writ application. No problem. See, however, seeks liberty to approach this court with improved pleadings, since according to her, the present writ application is deficient in pleadings.
But you already filed 4 or 5 writ applications.
Lords, those are connected to different matters.
Okay.
Arising out of the same petitioner's case, but different matters.
One is pending, one is pending.
Two are pending, my lords.
Yeah.
2 are pending. Grateful, my lords.
Item number 26.
Listen, item number 26, I have already filed in compliance affidavit, my lords. That affidavit was filed on 7th of August 2024. I have given a copy to my friend. On that day, my friend wanted to take instruction. There we have stated that there is encroachment and my lords, on that Gochara land, and we are going to demolish those encroachments, my lords. There is an order by the officer also. That is why also wanted to be, so that order has been passed by the collector. It pays, my lords.
There is no representation on behalf of the petitioner. So to press this application, according to you, it has been complied with.
Yes, because the decision has been taken to demolish, my friend is there. We have taken a decision to
Complied
demolish
with.
the encroachment.
My lord,
Order has been complied with.
my lord, order, they have not evicted, they are initiated the eviction proceeding, my lord.
But that was the direction.
My lord.
this learned counsel for the petition. Asoka's affidavit has been filed on behalf of the condemner, wherein it has been stated that this court's order, violation of which has been alleged in the present contempt application, has been substantially complied with. So stop. Considering the aforesaid, learned counsel for the petitioner does not dispute the said position. So accordingly, the contempt proceeding stands from it.
Item 43.
Item
43, Mana.
all matters will come on Tuesday.
Because 23rd is the last date for submission of bid.
23rd.
Yes, ma'am.
You could have dated earlier. Which item?
43, Mana. Item 43.
What is your challenge?
Your Lords, I was L1. So thereafter, but instead of issuing work order, they have cancelled the tender. I filed the writ application challenging cancellation. Notice was issued. Writ application as well as I in the month of Lord May. Now, Lord, on 3rd 8, they have issued fresh tender through another agency. That Lord, I have challenged. I have filed 3 applications.
That is not that urgent. You can apply, you can participate.
But once I have challenged it once, again if I
No, without prejudice to the decision, you can participate.
But that opportunity will be granted so that I will appear.
Participate.
Yes, ma'am.
Then should we dispose it off?
No, 3 interim applications.
Where is the question of we granting you this liberty? You can participate.
But since I have challenged the cancellation, once I will participate, I cannot challenge it.
No, you can maintain the challenge. Learned counsel appearing on behalf of the petitioner has submitted that the petitioner was found to be L1 in respect of the work in question, which has been re-tendered through another agency. First of last date of submission of bid is the
23rd.
Cancellation of tender notice. Initial tender notice is under challenge in the present writ application. First of the last date of submission of bid in the fresh tender notice is
23rd 8
2024. He submits that he may participate in the tender process, fresh tender process, but without prejudice to his rights and contention as raised in the present application. Let's this matter on 4 weeks. Who is for the other side?
Central government. Nobody is appearing. Nobody has a file also counter.
When did you file it? Was there any direction for filing?
Since May. Since May, notice has been issued to them.
Right. Yes. You have not filed count.
My lord, I am,
This case
is it 43, my lord? I am appearing for what, my lord?
Yes.
I am for the central
This
opinion number
matter
1, my lord. Other programs notice has been issued, but nobody is appear in the notice shown, my lord.
What do you have to say?
4 weeks. Matter on 4 weeks. So some of the petitioners shall be at liberty to participate in the this tender process without prejudice to his rights and contentions raised in the present writ application. 4 weeks, yes. Yes.
4 weeks September.
After 4 weeks, it will be listed. We have observed that you can participate in the process without prejudice to your rights and contention.
No, because I have filed 3 miscases. So because through another agency, they have issued the advertisement. I have filed an application impletion of party to him.
I have filed 3 applications, one impletion, another is amendment challenging the fresh tender call notice, and third is stay. My lord has granted, protected my right by passing
We
this.
will see on the next day whether notices are to be issued, required to be issued. In the meanwhile, if you get the work order, then